This is the Sunshine Ordinance Task Force Compliance and Amendments Committee meeting, a regular meeting scheduled for Tuesday, November 10th, 2009. Roll call, please.
On roll call, Member Craven Green.
Here.
Member Craven Green present. Member Johnson. Member Johnson excused. Member Nee.
Here.
Member Nee present. Member Washburn.
Present.
Member Washburn present. Madam Chair, there is a quorum.
Thank you. The only agenda change that I've heard and will entertain is to hear item number 4, or is actually to recognize item number 4, which is the hearing on the complaint filed by Randall Evans against the Ella Hill Hutch Community Center for allegedly not providing documents under Chapter 12L. And I understand that Mr. Howard Smith, Jr., the executive director of the center, is here, and that Mr. Smith is working with Mr. Evans and his group to provide documents and to comply with our request that they work together to do so. So as I understand it, the item will no longer be on our agenda, but I did want to recognize that everyone is here and appreciate the commitment to working together to resolve the request for records. So thank you all very much, and that item will therefore not be heard on the agenda. Okay, I was told please approach then if you have a question.
Well, first of all, I want to say thank you for actually emailing me this information, because I never was informed of this until actually your email got to me. So I do apologize, because I heard there was other hearings that we didn't make. Second of all, I'm a little unclear on, I saw the list of things that he asked for, and I'm trying to provide specific things to him, but I saw some things that I thought was kind of, shouldn't have been public notice, like I think he asked for my bank statements or something. So I want to know from you guys, what specifically do I need to, off that list that you've seen, could you kind of direct me on?
Oh, I see. Yeah, and I apologize. If I'd known that there would have been questions, I would have just kept you on item number 4, but I was informed that it was just folks just wanted to be acknowledged that they were here and working together, which is why I called it out of order. We can't. What I would say to you is that you should provide everything that you feel comfortable providing, that you're required to provide. You can even provide additional information that you're not required to provide. But if you have questions about specific the legality of producing specific types of information, you should confer with the city agency who funds you, and that city agency will work with you to help you review the statute and figure out what you can provide, or excuse me, what you must provide, and what you can provide, and what you would like to provide. So work with the city agency that provides the grant funding for the center.
I will do that, because the city agent with Representative Jill Fox, she's here from DCYF as well.
I appreciate you both coming.
Okay, thank you guys.
Thank you very much. Item number 1, please.
Item number 1 is the approval of September 8, 2009 regular meeting minutes.
Member name?
Yeah, I do have a few fixes. Page 4 of the minutes, page, excuse me, 9 of our packet. About the middle of the page, the name of Cynthia Goldstein is brought in, and I think it would be appropriate to identify who she is in the minutes. Second, on page 5 of the minutes, page 10 of the packet, down toward the bottom, recapping Mr. Warfield's comment, I think what Mr. Warfield meant to say is that the ordinance should mandate that the violation in the department be listed, et cetera, et cetera, et cetera. So after the word Mr. Warfield said, I think it's appropriate to insert the words, the ordinance should mandate that. And finally, on page 6 of the packet, 6 of the minutes, page 7 of the packet, second line, I believe that should be a declaratory sentence rather than a question mark, since this is in the minutes. And I would change it to say, the provision should say, rather than should the provision say.
Or the provision
The provision should say shall instead of should.
Got it.
That's all I have.
Public comment on the minutes? Seeing none, roll call to approve the minutes.
On the minutes, member,
Point of order. I didn't hear a motion or a second. I will so move.
Thank you.
I'll second.
Thank you. Roll call, please.
on the minutes, member Johnson excused, member Nee,
Aye.
Nee, aye, member Washburn,
Aye.
Washburn, aye, member Raymond Green,
Aye.
Raymond Green, aye, member Chair, we have 3 ayes.
Thank you. The next item, please.
Item number 2 is the approval of October 13, 2009 regular meeting minutes.
Comments from the committee?
I have a couple. Page 3 of the minutes, 16 of our packet, the third full paragraph from the top. Peter Warfield said that the number of pages produced does not necessarily mean, rather than necessary. So I changed the spelling. The other one is more substantive. It's on page 5 of the minutes, page 18 of the packet. The last paragraph down, the first 2 sentences mention a restraining order, and this is something that wasn't germane to the complaint, and it was something that was of concern to the complainant. So I think it should be that should be deleted. Any reference to the restraining order.
Yeah, I have a few things.
Well, first, before you move on that one, I mean, that is kind of a substantive change. I think this is him, this is the complainant mentioning it himself and responding to the rebuttal, right? It's not someone else bringing it up.
Right, except I think the reason he was mentioning that was because he was so upset about it being publicly aired. So I think, in keeping with his concern, it shouldn't be mentioned here, even though he was the one that mentioned it.
Right. I mean, my only, I think, comment at the last hearing was that I think it was relevant to the issue of why the person appearing at our first hearing was appearing and not the person directly working for the agency, because of the alleged, perhaps non-existent, perhaps existent restraining order. So, I mean, I do think it was somewhat relevant. I know that he was sensitive to it. He did submit a copy to our administrator himself. So, I mean, I just think it is what it is, and that's the public record. So, I mean, I think we should keep it in the minutes.
I agree.
Okay. I had a question mark after keep. I just remembered that being an issue. Another.
It definitely was.
The same paragraph, the 6th line down, B should be Ben. Person to contact had the other party been responsive.
Mm-hmm.
And then page 6, the second paragraph, second line, incomplete and do not give a full financial picture, rather than does. And that's all I have.
Thank you. Member Nee?
Yeah, I have some unsubstantive changes that I will email to the administrator, but I do have some other things that I wanted to clarify. On page 4 of the minutes, page 17 of the packet, in the 3rd paragraph down, on the first line, the placement of the word only to me makes the sentence ambiguous. Does only refer to, let's see, Mr. Moorfield clarified for Member Nee that the Board of Appeals is now only redacting emails. Did he mean to say only now? In other words, that it's waited this long? Or does only apply to redacting emails and phone numbers? Or does it apply to just redacting, does only apply to individuals? In other words, did Mr. Warfield say the Board of Appeals is now redacting emails and phone numbers of individuals only. It might be good, before changing this, actually, it might be good to clarify it with Mr. Warfield, but I think that as the sentence is written, it's vague and needs to be clarified.
If I may, I think the issue was that the Board of Appeals was redacting more information prior, but under the new policy, it's to redact emails and phone numbers of individuals. So, as I read it, he was just saying he clarified that the Board of Appeals is now only redacting those two pieces of information of individuals, whereas before they were redacting a lot. But I think if we just strike
Okay.
only,
Well, we could,
if we just strike only, it's the same, it just makes it clear.
or we could insert the word only after redacting.
Yeah. That would work.
That's fine as well.
Another thing I have is in the next to last sentence on that page, page 17 of the packet, Mr. Shoemaker agreed to, but on a rolling basis. Agreed with what? What did he say? What are we saying here?
He agreed to what was stated in the prior.
Okay, I
Paragraph.
see. So there should be a comma after the word "to."
Correct.
That'll make it clearer, I think. Other than that, I'm fine, except for some grammaticals.
Thank you. Any public comment on the minutes? Seeing none, is there a motion to approve the minutes?
So moved.
I second.
Roll call, please.
On the motion, Member Johnson excused. Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Craven Green?
Aye.
Craven Green, aye. Madam Chair, we have 3 ayes.
Thank you. Will you please call the next item?
The next item is hearing on the status of the September 22nd, 2009 order of determination of Rita O'Flynn against the Mayor's Office on Housing.
Thank you. I see Ms. O'Flynn in the audience. Is someone here from the mayor's office? Do we expect someone here from the mayor's office? Mr. Rustam?
Yes, Madam Chair, sorry.
Just wait. Do we expect someone here from the mayor's office?
I sent them the regular reminder, and that was it. I did not receive any response from them.
Okay. Ms. O'Flynn, we can call your matter now, or we can wait a little while to see if someone shows up. It's really at your discretion. Okay, we'll call the item. Ms. O'Flynn, you have 5 minutes to update us on the status of the compliance.
Thank you very much. Appreciate your time. I wanted you to be aware that as of October 27th,
Could you use the microphone, please?
I wanted you to be aware that as of October 27th, the Department of Technology has no record at all of any request by the Mayor's Office of Housing to restore Myrna Melgar's ITUN's deleted emails. As of November 3rd, the Mayor's Office of Housing has no documentation to support that they requested the Department of Information Technology to restore Myrna Melgar's emails. The Mayor's Office of Housing did provide a few email yesterday afternoon, some of which I had not previously seen, but they did not include other emails which I had seen and reviewed when I was on site at the Mayor's Office of Housing. It's unclear whether these emails were restored by DIT or somehow provided by another source. It's totally unclear where these emails are coming from. Mr. Hack, in his communication, when he provided these emails, indicated that he performed a search from 2004 to the present using string words 1672 Great Highway, 1674 Great Highway, Susan Suval, Fiona Ma, Rita O'Flynn, Mark O'Flynn, and Michael Palmer. I suspect that these keyword strings were done only for the headers or the subject lines of the emails, and therefore failed to produce the email that I previously viewed at the Mayor's Office of Housing. Specifically, I was looking for email to and from any regarding my property, 1672, 1674 Great Highway. Your order of determination stated that the Mayor's Office of Housing is directed to ask the Department of Technology to restore Melgar Iton's emails that fall within the timeframes I requested, and their response just falls far short of restoring the email. And it's only by providing this restored email that we will be able to, I'll be able to see what has been either inappropriate, deleted, or never provided in the first place. I've been trying to get these records from my property since spring of 2008. It's now November of 2009, and the Mayor's Office of Housing's responses consist of either saying that they've provided everything to date, and then providing email that I've either never seen or perhaps have received before. It's interesting to note that my property was addressed by the Mayor's Office of Housing under the HUD program in 2005. This last set of emails, there wasn't a single email from 2005 included in there, not one. I would like for you to please instruct the Mayor's Office of Housing to restore all of Ms. Melgar's ITON emails from 2004 to the present, and I would prefer that they go to someone outside of the Mayor's Office of Housing for redaction. I'm happy if the City Attorney's Office does that. Thank you.
Thank you. Is there anyone here to present facts that have in support of the complainant? Seeing none, again, is there anyone here from the city to respond? Seeing none, the matters with the task force. Ms. O'Flynn, if no one... Ms. O'Flynn, I have a question. So you received some emails yesterday on the 9th, is that correct?
I received some, yes, I did.
And who did they come from?
Oliver Hack.
And what specifically, can you read us from the cover letter or from the email that accompanied
Yes.
the production?
My apologies for the delay. All writings, records, and/or documents from, I'm sorry, that's the wrong one. Dear Ms. O'Flynn, attached please find all of Myrna Melgar's emails pertaining to your property since 2004. Beyond the attached, our office has no further documents, responsive documents. As a courtesy, I am informing you of the following in relation to Ms. Melgar's emails. I have searched over 15,000 emails from 2004 to the present. I searched using the following search criteria: 1672 Great Highway, 1674 Great Highway, Susan Suval, Fiona Ma, Rita O'Flynn, Mark O'Flynn, and Michael Palmer. The results of all the above searches are contained in the attachment, and I have a copy of that for you. It has some materials from 2007, and then skips 2004, 2005. There's materials from 2007, and then some from 2008.
Okay, so what I'm really interested in is the cover email or the letter. So it doesn't indicate what...
Here's the cover email.
Thank you.
He had sent me a previous email where I'd asked to see what efforts had been made since your first order of determination to the present regarding restoration of email, and he responded and provided me photocopies of what appeared to be discs of email. And I think you'll note here there's only one date for a 2005, one date for 2006, nothing for 2007, and several dates for 2008. I have no idea what this is supposed to mean, but I can provide you with this as well if you'd like to.
All right. Thank you. We have a copy of this. So I'm sorry, this one was... Can you explain this one again that you just said?
Is that what's the date on that?
This is the 11/3.
Yes, I had heard that the Mayor's Office of Housing was stating that they were attempting to restore these records and making efforts to restore these records, and as such, I was curious as to what they'd done, so I did a records request asking them for what efforts they had made to restore these records from the time of your initial order of determination to the present. Both DIT and the Mayor's... DIT responded they had nothing, and that was what was provided to me by the Mayor's Office of Housing.
Right, so this is... What they've produced then is just a PDF showing, and this was the attachment, the CDs.
And as I said...
It looks like there's one Melgar 1/28/2006, 7/27/2008, 8/31/2008. a bunch of dates in 2008, and
Yes,
then one
I-
undated one.
And I'm sorry, so they go from March to November of 2008. There's a single one for 2006 and a single one for 2005. But again, in the email that I received, the actual email that I received yesterday, there is nothing from 2005 in there. Nothing from 2004, 5, or 6 actually in there.
Okay, thank you. Well, we're kind of at a loss, as I see it. I mean, we have this email. It looks like perhaps they may have done what we requested them to. For whatever reason, they didn't find the emails that you're looking for, but we don't know that. We don't have sufficient information to say. We can surmise what these are, but it's unclear. Because we don't have anyone here from the mayor's office to explain it to us. Whether or not they complied with order to termination, which was to restore Ms. Melgar-Iton's emails and to search for emails responsive to her initial request. Perhaps what happened is they asked the Department of Technology to do so orally, and orally these documents were provided, so there may not be a written records trail from the Department of Technology to the mayor's office. But again, we don't know that because there's no one here to answer the question. So, Member Nee?
Yeah. Ms. O'Flynn, could you please reapproach the microphone? Sorry, I'm not trying to turn you into a yo-yo here. What I'm thinking is that we need further information from the city on this, and I'm just curious to know if we continue this for another month, what kind of inconvenience does that cause you?
There's actually some very important information that I need from those documents. I had seen documents that had indicated, that discussed sort of the details regarding the contract for the lead abatement, the details regarding statements that were made under penalty of perjury on the application. I've been trying to get those since spring of 2008, and they've really been stretching this out time after time. I didn't think they'd show up today in order to get another 4-week delay.
I'm sorry?
I was pretty sure they weren't going to show up today in order to get another 4-week delay.
Well, you know, our problem, as Chair Craven Green pointed out, is that they appear to have given it the old college try and not come up with what you were aiming for. Which is regrettable. My thinking on this, you may be seated.
Well, there's no email at all for 2005, which is
Okay.
when the property was, when the application went in, eligibility was confirmed, arrangements were being made. I'm sorry, it just seems odd that there's not a single email for all of 2005. That's just unreasonable. And I've seen some, and I have some. I just don't have the ones that they've destroyed or either never shown me before.
Thank you. Well, this is my thinking on this is that this is extremely difficult. It's difficult for us to find willful violation here. As much as we'd like to see Ms. O'Flynn get the record she's seeking, it annoys me that the mayor's office has not shown up here. And what I would recommend is that this matter be continued 1 month, or to our next meeting, which will be, I believe, on January 5th, and that we hold the mayor's office of housing's feet to the fire on this, telling them that either they produce the record or produce the information that Ms. O'Flynn is seeking, and be prepared to appear at the next meeting of this committee, and that their failure to do both their failure to do either one will lead to a finding of willful violation, because they have no business staying away from our meetings. And that alone, I think, is worth our pursuing. So I think we should kind of lay down the law to them here. That's my thinking. We should. My thinking is continue the meeting, send the Mayor's Office of Housing a formal note explaining what the situation is and what we intend to do.
And I agree with that. I would also add in that the letter to the mayor's office would ask them to identify the specific steps they've taken to comply with the order of determination, including when records were requested from Department of Technology, what specifically was requested, what was produced, what was searched, when, and whether or not any documents have been withheld, because that seems to be the other issue. Were any documents withheld for attorney-client privilege or other bases? So I would include that in the letter as well.
Do we want to, I agree with all of what you've said. So do we also want to ask them how they contacted DTIS, since Ms. O'Flynn, asked to see emails and they didn't produce any?
Right.
Just what process they
the
used.
manner in which they communicated with the Department
Right.
of Technology.
We need a thorough explanation from the MOH on what's been done, and we need them to be here to answer questions in case we have any. And then I think, in fairness to Ms. O'Flynn, it should be noted that we could find willful violation right now, and I don't think it would do a bit of good, because we couldn't prove it, and ethics would just throw it out. So in continuing it, we're actually doing what we think is in some ways in the complainant's behalf here.
I'll take public comment. Seeing none, public comment is closed. This matter shall be continued into the next meeting, and the chair will write the letter that was described for an explanation from the Mayor's Office of Housing.
And may I present other material electronically for your review at the next meeting regarding this issue?
Certainly, whenever anyone has information relevant to an issue pending before the Compliance and Amendments Committee or the full task force, that information should be submitted to the administrator how many days in advance of the meeting?
7 days, Madam Chair.
7 days in advance of the meeting to our administrator, and that will be included with the item.
That should be 7 calendar days. 7 calendar days.
I'll get the materials for you.
Thank you.
Thank you, Ms. O'Flynn.
Next item, please.
The next item is item number 5, the hearing on the status of the October 27, 2009 order of determination of Marilyn Molinito against the Zoological Society.
And is Ms. Molinito here? If you could, you have 5 minutes to give us an update as to any proceedings since our last meeting.
Okay, it will take me less than 5 minutes. I believe they had 5 days to provide the documents that I had requested, and I have not received them, including today's mail.
Well, thank you. You'll have a chance to respond as well. Other parties supporting the complainant with present facts and evidence? Seeing none, I'd invite the Zoological Society to respond, please. Thank you. You have 5 minutes.
Thank you. Good afternoon. Tanya Peterson, Executive Director of the San Francisco Zoological Society. The Society respectfully moves for reconsideration so that the Society can submit its position in writing. If a written document is not possible, then the Society offers a compromise with respect to this particular complainant brought by Mrs. Molinito, and produce minutes only to the extent that they reflect matters concerning the operations of the zoo. The Society seeks to submit its position in writing because positions taken during these proceedings have broad sweeping impact and change to the Society. Specifically, it's been stated that all committee meetings of the Society are now available for public access. This was not the understanding of the society when it entered into its agreement with the city in 1993, primarily for two reasons. One, committees were not part of the Rec and Parks oversight and realm of duties in 1993, the scope of responsibilities within the department. And two, the parties explicitly negotiated those aspects of the nonprofit that would be available to public access. In the alternative, in this instance in particular, the society, however, offers a compromise that provides the complainant with those matters in the executive committee minutes that concern the operations of the zoo. The genesis of this compromise is that, as you know, in 1993, the Rec and Park Commission turned the operations of the San Francisco Zoo to the already existing San Francisco Zoological Society, a group of unpaid volunteers formed in the 1950s to raise monies for the zoo. Unable to meet the financial burden and the demands of the zoo in the late 80s and 90s, Rec and Park had turned to the nonprofit for assistance. While the parties' written agreement increased the scope of the zoological's responsibilities, the basic charter of the nonprofit remained the same. A group of volunteers gathered to raise monies to fund conservation and education programs at the zoo. During these difficult economic times, I urge you not to alter the basic construct of the society, but instead to permit the society to redact those committee reports that reflect the spirit and letter of the parties' contractual relationship.
Thank you. Is there anyone else here to present facts and evidence on behalf of the respondent and Zoological Society? Seeing none, the matter is with the task force. Member Nee.
I think the position of the task force was made very clear at the last regular meeting of the task force, and particularly with respect to paragraph 16.2 of the lease itself, where it says the society shall provide public access to information concerning the operation of the zoo to the same extent that such information would have been available to the public pursuant to local ordinances if the Department of Recreation and Parks had continued to operate the zoo in the same manner as it did prior to the date of this agreement. Now, there are certain kinds of information that are redactable under sunshine, but what you're seeing, I don't see that what the executive director wants to redact here necessarily falls under information that is non-disclosable. The second thing is the executive committee under the society's own bylaws. The executive committee has the full powers of the board, and it seems to me that that means that the executive committee also has the full responsibility of the board, including when it comes to matters of public information. I'm sorry. I know I have a very difficult time agreeing with the request of the executive director.
I have a question for Ms. Peterson. It was just unclear to me, something you mentioned. The offer of compromise to provide minutes, copies of minutes that discuss the operations of the zoo. What do you mean by that, and what do you contemplate redacting from those minutes?
Well, what we're trying to continue to promote by the board is still the free flow conversation that might be ideas, fundraising ideas, grant making, exhibit ideas, etc., sort of a free flow conversation by our major donors. But to the extent that the executive committee starts to discuss matters that concern the operations, prepare motions that go to the full board, by practice, I've been a board member now my second term. Everything discussed and then formalized by the executive committee is then put forward to the full board of committee. So the executive committee has never acted on its own accord, but instead offers a robust motion or a...
Okay, that may be that's really going to
Okay,
Mr. Nee's
sorry.
point.
Yes,
My point is
you.
different. What exactly are you contemplating redacting, and what exactly are you contemplating providing under your compromise?
Right. We believe that the redactions would be minor, but they would be maybe perhaps unrelated comments by some of our board matters concerning theoretical possibilities, potential donor names, potential prospects of the society. A lot of donors like to remain anonymous. These things are what are often discussed at the subcommittee level.
So the only concrete example you can give me of something that you would reject under your compromise position would be potential donor names or potential
fundraising ideas, potential commentary on maybe the state of the economy. You'll get board committees members who just will speak as they wish on matters that aren't really relevant to the operation of the zoo.
So, I mean, to me, that is much of that is related to the operations of the zoo. All of that is related to the operations of the zoo. But there may be other issues on which you'd want to withhold them on, right? I mean, well, donor names are how to fundraise. That's related to the operation of the zoo. But you may have a different issue of which you want to withhold them on. And your argument is that it would be, I suppose, in the public interest to withhold identification of potential donors so that other competing nonprofits would not scoop them from you or hit them up as well, or some other reason such as that. That's a different argument. That's a different legal justification, if you will. And I'm not saying that necessarily applies under our ordinance, but it's different. I mean, all of this information that you've described to me is relevant to the operation of the zoo. You know, potential commentary on the state of the economy, someone kind of speaking extemporaneously, that happens in all sorts of board meetings. I mean, that's not something that's could endanger or damage the Zoological Society if that was produced. It's just perhaps not that relevant to the topic at hand. But so to me, that doesn't seem like a basis for, you know, withholding it. So, I mean, I guess I'm struggling to try to figure out. It sounds like you've offered a compromise, but it's not 100% clear on what that compromise would be. So we can't really evaluate it, even if we were inclined to do so. I believe that the DCA wanted to address us.
I just wanted to, Madam Chair, Jerry Three, the Deputy City Attorney with the City Attorney's Office, I just wanted to clarify that the at least my understanding of the order of determination was it based on the language of the lease, which provided that the documents maintained by the Zoological Society were public records to the extent they dealt with the operations of the zoo. So it appears to me that the compromise offered by the Zoological Society is in keeping with the language of the lease, which is the basis for the finding of order of determination. Of course, there may be some difficulty in interpreting that language, but that is the language that, it appears to me, sets out the parameters for the public records that are subject to disclosure to the public.
I mean, I agree. The commentary about making these executive committee meetings now open to the public, what have you, I don't believe that this task force went that far. That's exactly what the task force didn't need to go that far. How far the task force went was to say, records. Your lease provides that records are public records to the extent that the Rec and Park were still operating the zoo, right? So it didn't mandate that certain committees be set up or certain committees handle certain functions or that certain committees even be open. But to the extent that there's records of agendas and minutes from those meetings, those are public records unless otherwise exempt, okay? So the sky isn't falling. We haven't said every single one of your meetings have to be open or conducted in public. But what we've said is records about the operation of the zoo consistent with the terms of the lease, those must be turned over, right? So that's where we are. And now what I understand is we're talking about a compromise position where you would produce all minutes to the extent that they talked about operations of the zoo, and you would redact certain information. And that's kind of what we're going over, perhaps the difficulty that DCA Treat identified. What is information relevant to the operation of the zoo? And as I said, to me, fundraising ideas, potential donors, commentary on the state of the economy and how it might affect donors for fundraising, all of that is information relevant to the operation of the zoo. now there may be other grounds or other provisions under law by which you could withhold information that is exempt as member need identified. So I mean, that's kind of where I'm at right now, is what are we going to do with respect to board determination, which was produce the minutes and agendas. DCA 3.
Chair Craven Green, I don't mean to disagree or push the point too far. I just wanted to clarify that from my perspective, there is a difference between the operation of the Zoological Society and the operation of the zoo. Whereas fundraising for the Zoological Society, happens as a regular part of any nonprofit organization. If the zoo was being run by the city, I don't believe there would be the same sort of nonprofit fundraising happening. So there might be a distinction that could be made between the two activities.
And if I can comment, if it clarifies, if you look at paragraph 16.2 of the lease management agreement, it looks at what Rec and Park's functionality and operations were at the transfer. To the extent Rec and Park was handling anything, those records maintain and remain public. But Rec and Park didn't have an executive committee or any subcommittee. So the executive committee and subcommittees were with the society separately. And so to the extent Rec and Park was operating and those records would be available via Rec and Park, we agree. But Rec and Park never had an executive committee, never had all these subcommittees. It wouldn't, it's a city organization.
It wouldn't need to, right? And that's why I'm saying that.
But some parts of what Rec and Park did, and I'm sorry to interrupt, we do now handle, right? We now handle the animal care, the vet staff, emission revenues, what have you. That used to be Rec and Park's field of operations. We agree. We've now taken that on, and that remains public. So all that was with Rec and Park, we agree, remains public. There were certain aspects only of the society that were going to be part of that aspect, if that makes sense.
No, I see, and I appreciate that clarification. I mean, and I see the DCA's point and your point about fundraising potentially always having been in the purview of the Zoological Society as opposed to the zoo. I am familiar with associations, like national park associations, and the purposes of those groups are generally to do fundraising, special education programs, community outreach events, that sort of nature of that sort of thing. Do they do to the exclusion of the entity itself? Sometimes they do, sometimes they do in conjunction with them. I'm pretty sure if we go back to when the Rec and Park Department was operating the zoo, they did do some fundraising. Of course, they may not have done it that well, hence that's why the Zoological Society was formed, perhaps. So I mean, I do appreciate there's some distinction there and perhaps some overlap or differences in what we would determine is related to the operations of the zoo.
Well, perhaps we can offer the redactions to the city attorney's office, and is that a fair methodology of doing this? What policy we're trying to maintain is that, first of all, we're changing course with some of our donors. They don't want to see their names in minutes opining on the economy, if you will. They didn't have an expectation it would be. Vis-a-vis our formal board minutes and board meetings, there is an expectation these will be public. It's very formalized, very structured. There's that sense. But we want to still have a forum where major donors feel comfortable speaking publicly and candidly. So we're changing the rules on them sort of in due course. And I just respect some of their privacy and comments. And so that's sort of what we're trying to foster, still that forum for our major donors to think out of the box, if you will, but also to make sure that our operations are transparent and comply with the lease management agreement. And so one thought is we could offer the minutes to the city attorney's office, and to the extent they don't pertain to the, but I don't want to burden the city attorney's office, or we produce the redacted minutes and we see where we go. I mean, Mr. Jenkins of the zoo actually knows the minutes better than I do, so I don't know to the extent there would be.
Yeah, for example, if we had a copy of the redacted minutes with a kind of an annotation, as they do under the Federal Freedom of Information Act, where they say, redacted pursuant to X or redacted because of Y, then we could have a sense of how this is playing out in reality, and whether the complainant is satisfied with the minutes. The complainant may, I don't know, the complainant may not want information on donors' names, but I mean, so we're kind of operating in a vacuum, and that's the difficulty I was having in particular. Member Nee?
I'd like to ask the complainant if the compromises proposed by Ms. Peterson are acceptable.
Actually, I've read past executive committee minutes, which were provided to me last year by the Zoological Society, and I find it surprising that suddenly they've become so detailed and so full of big secrets that the Zoological Society has planned for their fundraising, and their donors making these bold, broad statements about the economy that would be of any interest to the public in general. My basic problem is I think that they would like to take this redaction to a very extreme, and I can see getting a copy that had, executive committee minutes, page 2, and have nothing on it because the whole thing had been redacted. I think it would be acceptable if they were saying, the Zoological Society is anticipating a $5 million donation from John Smith, and they redacted John Smith. I mean, I'm not interested in who their donors are. I'm interested in some other issues that are going on at the zoo that are relevant to some private endeavors.
Okay, Ms. Peterson has suggested redacting discussions on fundraising ideas, potential donors, discussions on how the economy might affect donations, people's ability to donate. Would those redactions...
Those don't interest me. I don't care if they redact that.
Okay. Thank you. In that case, it sounds to me like perhaps we've reached somewhat of an accord here. I would say that if Ms. Molinado would not agree to those redactions, I would be very inclined to support her. However, she seems to have accepted the compromise that Ms. Peterson has proposed. So, let's move forward from there.
Member Washburn?
I just have a concern. This seems to have worked out okay, but are we sort of stepping back from a position that we ought to be taken given what the law says? And because executive committees, are policy bodies, and so they're subject to
Okay,
the Sunshine Ordinance.
I would say that this particular case should not be in any way precedent setting. If somebody else tomorrow showed up at the Zoological Society's office and asked to see all minutes and agendas of the executive committee and would not accept any redactions, then I would say that the Zoological Society would be responsible for providing all the information requested. To the extent that it was, that the records being sought were disclosable. Couple things. First of all, when the Zoological Society signed that lease, it became a quasi-public body, quasi-public agency. And, it is performing work for the city that would otherwise be done by the city, operating the zoo. This is precisely what opponents of the lease were talking about in the first place. They were worried that the operations of the zoo would all of a sudden be a closed-door matter, and this is precisely what we don't want to see happen. As far as which committees and of the Zoological Society have to produce their records, committees serve in an advisory capacity to the board. What they do, the decisions that the committees make reflect what they influence the board's thinking. They're a part of that public policy. And so I think that since Ms. Molinado is willing to accept the compromises, then that's fine. But going forward, I would say that this applies to her case only. I believe Ms. Molinado wanted to make an additional comment.
She will be able to. She'll have, right now, she'll
Okay.
have, after we're done deliberating,
Okay.
she'll have the opportunity to do so.
Okay. So I would say that what we're doing here applies to this particular case only.
I have a question about minutes. And I've been on numerous boards and sat on executive committees, and we tended not to put a lot of detail in our minutes. You know, we would have similar discussions about fundraising and so forth. So what is our position on what should be in minutes and so forth?
There's a provision of the ordinance that requires for policy bodies the maintenance of minutes with certain information required. And so you can look at that. It's fairly detailed in terms of certain aspects, and it's fairly ambiguous or vague concerning other things. Generally, it's other than the minimum requirements set out by Sunshine, bodies are allowed to take minutes as they see fit or able to. But I think we have a little bit of a disconnect here. I mean, I don't think the task force reached the issue of whether or not the executive committee is a passive meeting body or a public body open to Sunshine. We did not meet that. The only thing we discussed were the records that exist from this body, whether or not those are subject to disclosure, and the answer was yes. So I just think we need to step back a little bit. That's the narrow issue we're dealing with, and I believe that's the narrow compromise. That's what the compromise is aimed towards. So if we can just remember that. Member Nee?
You know, one additional point. When people appear before the task force or the Board of Supervisors or this committee, and they want to speak their piece and they don't want to be identified, they have the right to do that. I mean, that's First Amendment. So if potential donor X appears at your meeting and says, I'm here anonymously, please, observe my right to anonymity, then, certainly that has to be taken into account.
It's hard to hit up an anonymous donor. All right. Anyway, so I think I also have a little bit of dispute about the precedent of this ordinance. I think the order of determination is what's precedental. Whether or not what happens at this committee, all we do is we say there's been substantial compliance, or we don't feel like referring it because the parties have reached a compromise, that's fine. So that aspect of it, what happens at this committee in terms of taking further action, is only precedental to the extent we do take further action. So the order of determination is what is a precedence in terms of due process issues. At this point, we invite the respondent, the Zoological Society, to provide up to 3 minutes of additional testimony if you wish. If you do not wish, that is fine. And then the complainant will have her turn. Ms. Peterson doesn't have any further comments. Ms. Molinado?
Yes, in view of the fact that in the future someone could request the records and they not be redacted, that they could go down and read the whole transcripts or whole minutes of the records, I'd like to withdraw my agreement to accept redacted minutes.
Thank you. Now it's public comment.
Good afternoon, David Pilpel speaking as an individual. I spoke on this matter at the full task force. I've spent some additional time thinking about it. I continue to disagree with the analysis that the task force applied. My understanding was that the Zoological Society was going to be requesting reconsideration from the task force. I don't know if that's still the case. It sounds like there are issues percolating behind me in the last couple of minutes with respect to this purported agreement. I disagree with the statement that Member Nee made a couple of minutes ago, that the society and that its activities became a public entity by agreement through the LMA. I don't believe that that's the case. I believe that certain operations, as carefully crafted out or carved out in 16.2 of that agreement, are to be treated as public records as if it were continue to be operated by the city. I don't believe that means that everything with respect to the Zoological Society is public, or that the Zoo Society or its board or any of its committees at any time became a public agency, a policy body, or a passive meeting body, or anything of that sort. Further, upon reflection, to the extent that records would be treated in the same way as public records as if the city were continuing to operate it, if the city were continuing to operate the zoo and I wanted records from the zoo or related to zoo operations, if it's under the Recreation and Park Department, I would make that request through the Recreation and Park Department. If I want records from the sewer enterprise or the water enterprise at the PUC, I go to the PUC. Same thing with Rec Park. Perhaps we should consider whether all public records requests with respect to the zoo operations under the agreement should be routed through the Recreation and Park Department, and whether they should handle the task of determining what's public, what's not, what's subject to redaction, where those burdens fall. I'm not sure that inserting the Zoo Society and treating them as if they were a standalone city department was exactly what was contemplated under 16.2 of the agreement. And I believe the agreement also says that nothing shall require the revealing of confidential donor information, and I think there's a similar provision in 12L.3 or elsewhere in 12L with respect to donor confidentiality with, and nonprofits. So I do continue to believe that the finding was on an improper basis, and that we should be going back and looking at that. And I do think that this sets a bad precedent with regard to how this agreement and perhaps others are analyzed by the task force. Thank you.
Thank you. Additional public comment? Seeing none, public comment is closed. The matters with the task force are motion deliberation. I particularly am of the belief that the best way forward is for the Zoological Society to enact its compromise and produce the redacted minutes, specifying with annotations what has been redacted. If, for example, Mr. Pippel is right in that the lease agreement has a provision that provides for donor confidentiality, that can be identified as further support for redacting that specific narrow information. I'm not sure I would have a problem with it in that case, as long as there's a grounds for withholding that information and for redacting it. So what I would propose is that we continue this matter to the next meeting, and in the meantime, get a date certain by which these documents will be produced in redacted form for Ms. Molinato's review, and then for the task force's further review at the next meeting. And we may find that there has been substantial compliance at that point, or members may feel that there hasn't been and wish to refer this on for a different finding. But that would be my proposal.
That sounds reasonable to me.
Well, I'm not happy with it, but that seems to be the consensus, so I'll go along with it.
Well, is there something else that you would like to see? I mean, this would be the time to let us know.
Well, Ms. Molinato has withdrawn her acceptance of the compromise. And, you know, in that case, we go back, as the chair has pointed out, to whether there's been compliance with the order of determination, which there has not been. And so my own inclination would be to send this back to the full task force with a recommendation for finding a willful violation. And if in the meantime the respondent produces the records requested, you know, then we don't have to take, you know, we can it stops right there. On the other hand, if by the time the full task force next meets, which I believe will be December 1st, if the order of compliance has not by that time been met, then we send it to ethics or one of the other enforcing agencies. That's my inclination.
My inclination is that the order of termination was to produce the records. It didn't say produce them without redaction. As you acknowledge, there are grounds by which you can redact information, even under the ordinance. So I think it's unfortunate that it took us to this point, but I think the Zoological Society is operating in good faith and offering the compromise, and I would like to see it work. So that's why I made my original inclination.
I think it's important that the complainant receive the records that she requested. And the full task force, I think, meant that she receive unredacted minutes to the extent possible. And we're learning that the law, 12L, has provisions for redacting donor names. So I would want to see the Zoological Society provide the information, redact what they feel they have the basis to redact. And then I guess we revisit it next time to see, if the complainant receives the information, she's happy with it, then that's that. If not, then we would revisit it.
So I would move to have this item continued to the next meeting with the request or with the order that the Zoological Society produce the minutes to Ms. Milanito with a copy to the task force, redacting information it feels it is justified in withholding, with annotations as to why the information has been redacted. And we'll move this to the next month's hearing to determine whether this committee believes there's been substantial or full or non-compliance with the order determination.
Yes, that seems reasonable to me.
Would you second that motion?
I would second it, yes.
Roll call on the motion.
On the motion, Member Nee?
Aye.
Nee, aye. Member Washburn?
Aye.
Washburn, aye. Member Craven Green?
Aye.
Craven Green, aye. Madam Chair, there are 3 ayes.
Thank you. So if the Zoological Society could move forthwith and hopefully within the next few weeks, I would say 2 weeks at the outset is plenty of time to do those redactions, have them to Ms. Milanito and a copy to the task force. Hopefully this issue will be resolved. Thank you both. And next item.
Item 6 is the hearing on the status of the October 27, 2009 order of determination of Peter Warfield against the clerk of the board.
Do we know if Mr. Warfield is going to be attending? Oh, actually, thank you. I will suspend this item at this time in our agenda. It's the normal time we take general public comment for items not on the agenda. This is item number 11. I would invite general public comment on items not on the agenda. Seeing no general public comment, that item is closed. We are back to item number 6. Mr. Rustum, have we heard from Mr. Warfield?
Madam Chair, no, we haven't. I did send him the reminder, though.
And we haven't had any correspondence or otherwise to indicate that he would be here?
Nothing, Madam Chair.
Is there a representative from the clerk of the board here? Please approach. If you could give us an update on the status.
Okay. Madeline Licavoli, Deputy Clerk, Clerk of the Board of Supervisors Office. The Clerk of the Board's office has reviewed its redaction policy, and effective today, the policy will be as follows. With respect to the Board, Commissions, Committee, Task Force applications, we will redact home address number, telephone and fax numbers, email addresses, social security numbers, and date of birth. Depending on seat identification, if there's a specific residency requirement, then the home address number will not be redacted. Form 700s will not be redacted. In terms of communications, all general communications to the board or the clerk of the board's office will not be redacted.
Okay, it's hard. I was trying to write it all down. Is that going to be in writing somewhere?
The clerk of the board will put out, as we did back in May of 2008, redaction policy revised, and we can provide a copy to the task force.
Okay. Did you have any other comments? I didn't mean to interrupt.
No.
Okay. So just so I have clarity, basically all personal information for applications for seats on boards or commissions will be redacted.
Correct.
And then Form 700s will not be redacted.
Information on there will not be.
Okay. And then the third category, I didn't quite catch that.
In the case where there's a specific residency requirement for certain seats on certain task force boards, commissions, then the home address number will not be redacted.
And by home address number, do you mean that, like I live at 1352 Sanchez Street, anyone can figure that out. 1352 will be redacted, or 1352 Sanchez?
No, previously we were redacting the whole address, 1352 Sanchez. And now in this specific case, if it's, identified, we will not redact 1352 Sanchez.
Okay. So so it's street and house number?
Yeah, the
or apartment
number. Mm-hmm.
Okay. And then the final piece of information?
On general communications going to the board, things that appear on our so-called C page, communications page, we will not be redacting any information, no personal information that we had been in terms of home address, email, anything else they may have provided. Those are generally the main things, might be telephone number, email, and home address. So we will not be redacting anything of that nature on general communications that come in.
Okay. And the only other thing I see that, and I think now we're addressing both of the complaints together in a way, but with respect to this particular item, this is with respect to the final category. So this was the C file, essentially. This complaint deals with support and opposition letters related to legislation being considered by the Board of Supervisors. So support letters, or letters in support or opposition to legislation, those would go into your C file?
Right. In other words, they would.
Right. So it seems that the board has reversed its policy with respect to that and is going to come into compliance with our order of determination, which was you should not redact personal information. And I think that's a good way forward. Did you happen to, Mr. Warfield had requested information from the C file, and I guess copies had been provided to him that contained redacted information. Are you able, or were you able to provide Mr. Warfield with copies of the unredacted information? Or you may not have been able to because you didn't know what was requested in the first place. So
exactly. In his complaints, he did not specify particular items, and without that information, we would have no way of knowing.
Okay, but if Mr. Warfield were to provide to you, I wanted these following pages from the C file that have been provided to me redacted, if he was to give that request to you, you'd be able to comply with that and provide unredacted information?
Well, I may have to check on that, given that the policy effective today, but I guess if he asked for them at this point, yes, we would provide them.
Okay, thank you. So it sounds like, members, we have compliance with this order of determination, and I appreciate the clerk's office revision of that policy. I think it's a step in the right direction. Other comments by members?
I think it's a
Seeing
positive
none,
thing.
we'll take public comment on this, and then we'll wrap it up to the extent there is any. Public comment on this item? But please remain for the next one. Thank you.
David Pilpel again. This is an interesting turn. I want to think about further the implications of this policy change. A couple of questions immediately spring to mind. Would this policy change affect the task force, the Assessment Appeals Board, the other entities under the Board of Supervisors and the clerk's office? Would it further extend to members of the Board of Supervisors to the extent that they have separate records from the clerk's office directly? And finally, if a member of the public wished to comment on general legislative matters and wished their contact information be redacted, would they have an option to so request and have that request be honored, or would their only option be to either mail a letter with just their name on it or drop off a comment letter here and therefore not be able to email or fax in comments to the extent that it would provide revealing contact information that they might not want revealed. So how do you balance that an individual might have a heightened expectation or request with respect to their personal privacy in regard to that sort of communication? Those are the things that immediately spring to mind. I'm sure there are others. Thanks.
Thank you. Additional public comment on this item? Seeing none, public comment is closed. I don't think we have anything more to say on this one. I think we appreciate the clerk's office looking at the policy and revising it. I'm sure, and I hope and expect that if people want to submit testimony anonymously, the clerk's office will work with them to facilitate that, as our administrator does for anonymous complaints before this body. And so hopefully that won't cause a problem and allow people the right to petition. Sounds like it will, and also allow the full openness and transparency. So I do appreciate that. This item is concluded. Let's call the next item 7.
Item number 7 is the hearing on the status of the October 27, 2009 order of determination of Peter Warfield against the clerk of the board.
Thank you. And this is the item that deals with private information concerning, or information concerning the home address, email address, telephone number of members of committees, this particularly the Library Citizens Advisory Committee. If you wanted to approach again, please. Thank you.
Okay.
I think we heard the revised policy as it will be. Are there comments from members of the board? Member Washburn?
No.
I'll just say that I find it, interesting, if you will, that information on applications to sit on boards, including home address or business address, I guess wouldn't be redacted, but home address, if they choose to use home addresses, is going to be redacted. I do think that's something that's very valuable in terms of trying to get geographic diversity and representation from different parts of the city on different boards. It's something that I think would be of interest to not only the Rules Committee, but members of the public trying to figure out whether a particular board was representative of the city. Geographic diversity is only one aspect of diversity. I acknowledge that, but I don't think there's that much privacy, or I don't think there's an expectation of privacy in that information when you apply to be to sit on a board or a commission, or privacy interest that's worth protecting in that way. I mean, the other issue that I have generally, I usually don't have a problem with redacting phone numbers, but I do feel like if an email address is the address that an elected or appointed official is going to be using to receive official communications from the city, that should be a conduit for members of the public to also communicate with that individual. The Board of Supervisors, or people who are employees, have a city-provided email, and so it's very easy to communicate with them. But members of the public should be able to communicate with a member of this task force, a member of the Board of Appeals, in the same way that the administrator does. And I've been a proponent of allowing people to set up a Gmail account or some other city-provided account, even if that was feasible, to allow them to create that ability to say to the administrator, I'm going to use this email account. This will be my email account to which you should send me information, agendas, updates, queries. It should be also the email account that members of the public can be given to have access to me. So, I mean, I really think that redacting email without providing that alternate is a problem. I think it shuts down the ability of members of the public to reach out and communicate with or seek assistance from, within their ethics code restrictions that they have from members of boards and commissions. So I do find it troubling to that extent. Member Washburn?
I guess when I was listening to you for the last matter that we discussed, I thought by applications I was thinking of those members of the public who do not end up getting appointed to a board or commission. They apply, but their application is unsuccessful. So they haven't in fact become members of a policy body. So I guess I was just assuming, although you didn't say anything about this in particular, that those were the applications that could be redacted, and that because once you're appointed to a board or commission, you fill out the Form 700. Is that the?
It's not totally coextensive. Many members of boards and commission have to fill out a Form 700, and the information they put on their Form 700, you can, in fact, I believe, use a business address for your Form 700, or many people use a personal address for their Form 700. But all of the information you put on your Form 700 is not redacted in person. If you go to the Ethics Commission in person to go look at the Form 700s, you have full access to all of the information. Nothing is redacted. I believe when the Ethics Commission posts it online, they redact certain information like phone number and email address, and perhaps personal addresses as well. But people can get the information if you go to the Ethics Commission in person. But not every person who's elected to a board or commission or an advisory committee, or nominated, appointed, or elected, I should say, fills out a Form 700. So, for example, members of the Library Citizen Advisory Committee, I believe we learned at the full task force hearing, do not fill out Form 700s.
Right.
So I guess the question is, for successful applicants, their information will also be redacted.
All applications.
I assumed that.
Yeah. Now, the Form 700, which on the Form 700 itself says in terms of address, it'll say you may use a business address. So if individuals use a business address, fine. But if they use their home address, with our new policy, we are not redacting that. We're not redacting Form 700.
Because it would make sense, because Ethics Commission doesn't.
But it applies to all of the application forms we receive, whether people are appointed or not.
So then it looks like we have a sort of a two-tiered system here, where some members of some boards and commissions or advisory bodies will be providing personal information that the public can see, and others won't be.
Well, you have the option on the Form 700 to use a business address. But for example, when I was at my firm, I would put my firm address. Actually, I believe I put my home address and put my firm email address, because that was the email address I used,
Right.
and my work phone number. So it is a little bit different if you have a business address or information to use. I chose to use my personal address so they could ascertain I did live in the city and met the residency requirements. So
then I think we still have a problem here.
I think there's a potential difference of opinion, yes.
Yeah.
Any suggestions on what we should do?
Amendments to the ordinance.
I personally would like to see it in writing, be able to really, I think we've gotten the gist of it, but to be able to see it in writing, I think would be helpful to me. My instinct, which is terrible, of course, in terms of continuing matters, but I would continue this to the next hearing so that we could have the policy in writing. We can look at it and we can make a decision as to whether we believe this would be appropriate to, refer for a finding of violation of the ordinance under our order of termination, or I don't believe it's willful failure, but some others might, for referral to the Ethics Commission, or whether or not there's a potential to work with the clerk's office to revise their new policy or set up a procedure by which, people who are on commissions are given the opportunity to have an email address. If they use an email address, they will be disclosed, but they have the opportunity to provide an email address which they will use for city business, as to which people can contact them. I think that's a very good resolution. of all the interests involved personally. So my instinct would be to continue this, to see the policy in writing, and to see if there can be any further meeting of the minds, and to test the waters as to what the commission or what this committee would like to do in terms of any additional actions or inaction.
I agree. I think that's a good course. I think that the Board of Supervisors offices, or the clerk's office, has made really an excellent effort here, and that we continue working in that spirit so that there's a full so that we have a full understanding of what the policy is.
Yeah, and maybe just some testimony as to why the policy was decided the way it was, and what are the interests that the clerk's office is seeking to protect, and whether there are any ways that we can balance, provide individuals more access to be able to communicate with members of the boards and commissions, but not necessarily intrude upon their privacy to the extent that a reasonable expectation exists.
Yeah, I like the idea of continuing the matter. I just to comment, a week or so ago, I had a brief chat. It wasn't that brief, really, with Angela Calvillo, and she impressed me as somebody who's very sincere about wanting to advance sunshine. She, many years ago, was a staff aide to then Supervisor Amiano, who, as I think everybody knows, is one of the staunchest proponents of sunshine this city has ever seen. So I believe that the office is trying to move forward with sunshine, and but there are obviously some, as this case points out, there are some other matters that have to be considered. So I think the written a written statement going forward would be very helpful, and we look forward to discussing this matter further.
So you'd like a copy of the written policy then?
I think it would be helpful, yeah. As soon as you can reasonably come up with it. It would help us if we have some time between now and our next meeting, which is December 8th, I believe, to kind of digest what you have.
To look at it, maybe send it out for other analysis, compare it with other cities' policies, that sort of thing.
Sure. And in terms of the email address you talk about, possibly, this is one that would be provided by the city for members of boards, commission, task force?
Either by the city or offer the applicant or the successful applicant the option to say, we need an email address. This email address will become public. What email address do you want us to use to communicate with you and to release to members of the public? And so that way, for example, someone who, if I didn't want to use my firm email address, wanted that strictly for my firm use, I would say, well, let's use, erica.sunshine at gmail.com, and that would be the one I would set up, that I would receive communications from Mr. Restum about the task force, but also emails from members of the public to the extent that someone wanted to communicate with me. So just providing a mechanism by which not only does the city communicate to me, because we get emails from our administrator about scheduling and other issues fairly frequently, but also, it would allow members of the public to be able to reach us through the same mechanism. So either that could be provided by the city, that might be too much administrative headache, but a medium way is just basically giving them notice that this will be released. Please select one that you don't mind receiving emails from members of the public and emails from the administrator from the clerk's office, or whoever the secretary is of the board or commission. So we'll take public comment on this. We did not take public comment on this one. We'll take public comment on this one and wrap it up.
David Pilpel again. Some other quick thoughts. I've suggested in the past that with respect to applications, in addition to the home address, it would be useful to ask for the district, the supervisorial district that people live in, and to the extent that that information is provided, I don't see a good basis for redacting that, and I think that might be useful in terms of understanding geographical diversity. Although I have taken the position that home address should be redacted, I don't take the position that the supervisorial district should be. Second is with respect to Form 700. I have no quarrel with the unredacted Form 700 being available in the office. I have a concern if the Ethics Commission provides only a redacted version online and a full version in the office, why the clerk of the board's office would operate differently and have an unredacted version available online as part of the packets for the Rules Committee. And so I would suggest that Form 700 be, Forms 700? Hard to tell. That they be available online in a redacted fashion in the same form as the Ethics Commission provides it, but that the unredacted version be available in the office. I think there may be some other provisions in state law that limit the access to home addresses for certain people. For example, if someone does become a successful applicant and serves on the police commission, it might not be appropriate for their home address to be available in that way. I don't know. I know it extends to law enforcement officers. I don't know that it extends to members of the commission overseeing them. There may be other instances where there is, for example, a law enforcement seat on the entertainment commission where it may be applicable, and so we might run afoul of that. There may be some particular instances. And just finally, I do support the notion of the city providing an email address for contact if that's really the base of part of the concern here. If just as all employees of the city that need to have an email address, so too could appointees to boards and commissions and other bodies that require contact have a city-provided email address, and that might get at the larger root of the issue rather than the home address and phone number. I guess I'd also note that to the extent that people provide a cell phone number that a clerk or a department head or somebody can contact them either on a general matter or in the case of an emergency, I'm not sure that that then should be subject to disclosure to the general public. Just because for example, the president of a commission may need to be accessible to the general manager of a department doesn't mean, in my mind, that a member of the public should have the same access to their cell phone number. Thank you.
Thank you. Any additional public comment? Seeing none, this matter is closed, and we'll continue it, hopefully, for further review of the written policy. Member Reston? Mr. Reston?
No.
Thank you for attending.
Item number 8 is the developing recommendations for the proposed electronic document retention policy of the Sunshine Ordinance Task Force.
Any updates on this item? I believe there's nothing in our packet, so I think it's probably a work in progress still. But Member Nee or Member Washburn?
I had submitted some questions, edits, and so forth that you have a paper copy of. They were.
I think it's for the next item, the item 9.
Oh, I'm sorry.
That's okay. We're on the electronic document retention policy.
Oh, yeah. I don't have that in my.
I have no updates.
I don't have that in my packet. So, but I did start doing some research on this, as I promised, and there's an enormous amount of information available, a lot of different industries, governmental entities, and so forth looking at this issue. And I emailed Richard about this the other day. I'm finding who the bodies are that are developing best practices. I have a copy that I brought with me of the Sarbanes-Oxley's document retention rules and best practices. I have some material from the National Archives and Records Administration, who surveyed 5 federal agencies who are implementing records management application software. So there's no, as far as the federal government, there's no uniform way that agencies manage documents. And but the National Archives and Records Administration is developing best practices, which I wasn't able to locate just yet. And there's also the there's a National Records Association, which seems to be the professional association in this area. So what I had proposed is that, given the huge amount of information here, that we should think about developing a work plan or scope of work, going forward. And I think that their document retention is one thing. I think document retrieval is what we're really interested in here. That seems to be the problem we keep running up against with the public, is inability to
Only because they haven't been retained.
Well, yeah, that's one issue, retention. And I know the city has policies for destroying documents, and it seems to happen rather quickly in some cases. But a couple of conversations we've had with departments and agencies is that indexing and coming up with a way to retrieve documents is particularly emails, is very difficult. So there's a lot of information out there. I think we need to figure out where we want to go and who we want to be working with. So
I think you've touched on a lot of the places I would recommend going, especially the National Archives and Record NARA, whatever that is.
And again, I think
NARA.
we need to work with the Committee on Infotech to see what's there and what's coming down the pike. What are systems capable of now, and as they move into new formats and cloud servers and so forth, what's going to be available, because it'll affect bandwidth, the amount of storage, the storage capacity of what records are currently being retained, and storage capacity of records that are backed up and before they're deleted.
Right, I believe we heard from a representative from Kuwait that there was going to be an RFP or some other type of proposal sent out to hire a consultant who would then talk to or seek information from different constituents, agencies. So the police department or the PUC or the clerk's office, about what their needs were in terms of records management and capacity, and then also probably in conjunction with conversation with the city attorney's office, what their responsibilities were for records retention and retrieval. So I'm not sure if that has gone out yet or if that process has started, but we should probably try to find out.
I think we should be one of the constituents at the table too, as representing the public on that. It was interesting, some of the agencies that the National Archives and Records Administration looked at, there was the Nuclear Regulatory Commission, and here's one I think that's important to look at, is the U.S. Government Accountability Office. So, so we should really, be watching Kuwait and making sure that, but I think we should bring something to the table, that systems, in order to comply with the sunshine laws, need to have these capabilities, and really bird dog that so that it happens.
I'll send an email to various people in Kuwait and figure out where they are in the process in terms of specifically with respect to their RFP or the other proposal to hire someone to go out and do this type of research with the different kind of constituent branches of the government and figure out what their needs are. I'll figure out where that is and reiterate that we want to be a part of it.
As representatives of the public.
Mm-hmm.
Should we have some allies standing with us, representing that constituency?
Such as?
Oh, I don't know. I was just wondering.
You mean like Californians Aware or First Amendment Coalition or those types of nonprofit groups, or?
I think possibly.
Well, certainly I think once we have information or figuring out what the city's proposing, we can try to keep those entities in the loop and see if they want to comment on specific proposals. I guess that's really up to us to figure out where they are, where Kuwait is. I know that they had budget issues, so that their implementation of the switch to the Microsoft Exchange server was halting. So, all right, so it sounds like we're making progress on this very thorny issue, and we will continue to do so. We'll continue this to the next meeting. Thank you, Member Washburn, for starting that and starting to review the best practices. The next item.
Item number 9 is the discussion on the proposed amendments to the Sunshine Ordinance, specifically but not limited to sections 67.15, public testimony, and 67.35, responsibility for administration.
We've had two specific proposals on this, or requests to look at specific sections of the ordinance. I guess we can look at Rick Nees first, and he has a proposal to amend 6735, which our current revisions start on page 141 of the packet, and then that's what currently we've approved, and then Member Nee's suggestions start on page 50 of the packet.
Madam Chair, I also want to call attention to one item of public comment that came in, and that's from Bruce Wolf, who's a former member of the task force. I don't know if the other members of this committee have had a chance to read Mr. Wolf's comments, but I think that they're important and relevant, and I think they should certainly be taken into consideration as we move forward with my particular proposal here. First, my purposes in offering this particular new language is that number one, it kind of delineates responsibilities between the mayor and his department and the board of supervisors. I think a delineation is a good idea, and also with respect to 67.35B2, it's one thing for the task force to try to move things forward, but I think what this does really is to kind of give some teeth to our efforts to make technology sunshine friendly or sunshine responsible, if you will. So those are my intentions. Now, it's as far as 6735B2, as I note, maybe we want to put that somewhere else. But I think it is important that it be in the ordinance somewhere. And then, again, I would point to Bruce Wolf's questions as worthy of consideration. We may want to continue discussion on this particular section to next month. One thing I will also mention here, because of all the continuances we've had, at this point it doesn't look like we're going to make the June ballot with this. I have been informed by an aide to Supervisor Alioto Peer that we would have to have it to the board by this December 15th for us to make the June ballot. So
That's much earlier than I thought.
it's much earlier than I thought. I think it's much earlier than we all thought. And I think what's going on here is that even if just 4 members sign on to it and want to put it on the ballot, it still has to go to public hearing. That would be kind of, as I understand it, pro forma. If we get 4 signatures, we got the 4 signatures, and it's the public comment is kind of a pro forma thing. I wouldn't think the public comment's necessary because this entire process has been very public. However, it's there. We have to deal with it. So that means I guess that to get it onto the November ballot, we would have to have it to the supervisors late April, early May. Gives us a little more time to play with. But I just wanted to throw that thought out there because we can try to tweak this and refine it forever. And of course, it's better to have it right than get it rushed. But at the same time, it's these are things we have to consider. There are a lot of people who are getting very frustrated at the amount of time this has taken.
So when would the next opportunity be to have this process, and what's the deadline? I mean, that's what we really should know.
Well, I'm assuming that based on what Supervisor Alioto Pier's aide told me, there's kind of a 6-month window. In other words, December 15th for next June. So I'm guessing that to get it on the November ballot, we would have to have something up and ready to go by late April, early May. And what we would need to do, and maybe we could begin the process now or next month, is to put together a summary of what the major changes are. Once we have it nailed down, we're going to have to do that.
Yeah.
And I think a good starting point is the analysis with annotations that Member Craven Green gave to us, 3-4 months ago. Very, very useful document, and I think that will be a good starting point.
And no, I think that makes sense as well, because that's the question the supervisors are going to want to know an answer to is, what are the major changes? What are the controversial changes? What are the, not really as concerned as the cleaning up or typographical changes. So something that lays out the significant measures is definitely, I think, important. With respect to this, and so I think that's a good goal to have. And for the next meeting, I will try to figure out a better way of doing that than just the annotations. The annotations were kind of the first step, and I guess we could cut and paste the annotations in some other method and make it more of a cover sheet if you think that's more kind of what people are used to looking at. I'm used to looking at footnotes, but it's a very perverse lawyer thing. So maybe just pulling those out and putting them into a cover sheet would work better, or
Lawyers and professors.
exactly, end notes, or even worse. All right, well, I will try to start working on that and have that for our next meeting.
Okay.
With respect to your suggestion here, is your suggestion trying to not avoid, but rectify maybe the situation where recently supervisor passed legislation requiring audio or video recording of meetings be posted online, and then we were informed that no one had any capacity to do so, and so it's kind of been more of a sporadic thing. I mean, is that kind of what you're trying to avoid, or I guess I'm just what's the goal?
Well, the goal is to get the Board of Supervisors in on the act, so that when technology advances, the board will be responsible for going to departments and agencies and saying, what are you doing? We're here to hold your feet to the fire. It's one thing for us to do it, but we don't have any kind of enforcement abilities or anything like that. If the board has that responsibility, I think the departments and agencies are going to take note of it. They're going to heed it.
I mean, don't they now? I mean, I don't see what the difference is between now and then. I mean, now, this was the difficulty. Someone refresh my recollection as to who passed the legislation. I can't remember whose office it was recently with respect to, anybody remember? With respect to requiring departments to, requiring commissions and meetings to audio or digitally record. We can't remember. It was either Mercarimi or I thought it was Mercarimi, but I could be wrong about that. Anyway, so there's a law passed, right? And I guess there becomes a change, Jeremy, right? If they pass a resolution saying this, that goes into the administrative code somewhere. Is that right? Generally speaking, I guess it depends on what they pass. But if they pass a piece of legislation that says the city's commissions and boards and commissions shall do this, and so it's like an affirmative requirement that eventually would wind its way to the administrative code. Yeah.
It depends on which code was amended.
Yeah.
Many things are in administrative code, but other things are in other parts of the codes. And then the responsibility for ensuring that there's follow-up by the department rests with the Board of Supervisors. If the board member who had the legislation pass is otherwise focused or loses interest in that and does not pursue it, then if the department, particularly if they were not consulted or pushed the idea themselves, may not pursue it. So, that's just the way it works practically. If there's not someone there ensuring, particularly with the purse strings, that it is funded and then enacted, then it won't be.
Right. So I guess if your goal is to try to avoid that situation in the future, I don't know, how do we do that?
This is going to require a lot of work, and there are some other questions that I have. I should have put more. I guess one of the questions too is, what if the board shirks that responsibility? There's nothing here to force the board to do that except to tell them they have to. But what if they don't?
I'm wondering if having this provision in here will affect whether we can get 4 supervisors to stand with us to put this on the ballot. The politics of having them have this responsibility.
And I think it may fit better in 6730, the new 6730. On page 122 of the packet, which is minimum standards, electronic records, computer systems, web postings. So it may fit better in that section. If your specific focus is in fact on technological changes or legislative changes really affecting the city's electronic record storage and retrieval capabilities and requirements. Probably should go somewhere in there, I would think. But I think it's something that we need to think about, and we try to mandate, in revising 6730, mandate certain minimums that have been suggestions before, one could argue.
Where's the mayor's office in this? What responsibility does the mayor's office have for ensuring that departments comply with these changes? Isn't it a split responsibility in this city?
The mayor's office has control over certain departments. So the mayor's office may not have control over boards or commissions. Those typically are staffed by the clerk of the board in terms of staff resources, is my understanding, except for there's some that spring forth from the charter, like the Ethics Commission. But then all of the other departments are, the executives of those departments really, I guess, report to the mayor. Maybe.
Other than elected executives.
Right, that's right, exactly, other than elected executives, yeah. So the treasurer and the recorder, or the assessor, I should say.
So if the city departments and policy bodies, again, those are fall under separate, one under the mayor and one under the Board of Supervisors, ensuring that these bodies, departments and bodies bring their policies, practices, and systems into compliance. Again, it looks like it's going to have to be both the mayor and the Board of Supervisors.
This is a thorny political question. What powers do the Board of Supervisors have over various city operations? It's usually just the power of the purse strings.
Well, they have several powers. They have the power of the purse strings. They have an investigatory power, so they can actually call investigatory hearings and issue subpoenas in certain circumstances to find out information necessary to find out whether, for instance, if a law is not being complied with, they can make an investigation into that. And they have significant powers in that regard that are very rarely, if ever, exercised. So they do have powers. But in terms of the administration of the departments, that's largely an executive function. The difficulty is that the incentives that I think the Commission is concerned about tend to be different depending on whether you have the executive may not have the same incentives to more as fully provide transparency as say an oversight body like the Board of Supervisors. So there are different roles. The difficulty is if you're doing an investigation, you could turn up the fact that a department is not doing what you would like for them to do in this amendment, but the board's powers to make them do that are very limited. They could say, well, we could cut your budget next time, but that department may have other things that are very necessary to be funded, so it becomes a difficult task to get a specific goal accomplished through a budgetary process. And I think the reality is unless there's an organized constituency with some political power pushing something, then you have this difficulty, and the real solution is to have that organized political constituency. Another way that you can address issues like this is, for instance, in the Sunshine Ordinance and in the ethics ordinances, there are provisions where if there are violations, a member of the public can bring a lawsuit. That can be an effective means, but it's a pretty big club to use for something. So you should probably use it judiciously, I'd say.
Well, so maybe we'll continue discussion on Rick's proposal to give him time to contemplate that and contemplate whether it might need to be changed or where it would be more appropriately housed. And maybe we need to revisit the new 6730 and figure out if that's strong enough.
Agreed.
In terms of setting minimums. Before we turn to Allison's comments, there was another request that was made for us to consider changes to 6715 public testimony, which in our revisions, I believe, is still the same. I think the request was with respect to Supervisor Alioto Pierce's recent proposed amendment requiring that committees of the Board of Supervisors hold general public comment. So right now, 6715 deals with general public testimony. Every agenda for regular and special meetings shall provide an opportunity for members of the public to directly address a policy body on any items of interest to the public. Any item of interest to the public that is within the policy body's subject matter jurisdiction, provided that no action shall be taken on any item not appearing on the agenda. On page 88, it goes on dealing with special meetings. And then, for some reason, we've moved, however, in the case of a Board of Supervisors, the agenda need not provide an opportunity for members of the public to address the policy body on an item that has been considered by a committee. So this is really just it's a narrow carve-out. It's the same as above. It's just been moved. But, I mean, under my reading of the ordinance, the Board of Supervisors committees have to have general public comment because it's every agenda for regular and special meetings. So it's my analysis of the issue is it's already provided for, but clearly it's not what the Board of Supervisors is doing. Jerry, do you know why or how the authority is for committees of the Board of Supervisors not to have general public comment?
Could you say that again?
Sure. My understanding is that the issue that we had addressed and we'd found, I think, Supervisor Daley in violation, or the Rules Committee in violation, for failing to allow for public comments on an issue that had been withdrawn. And we noted that one way of avoiding that issue or avoiding cutting off public input on an agenda item that may be withdrawn is to allow for general public comment, through general public comment, the opportunity for members of the public to comment, for example, on withdrawn items, but that this particular committee did not have an item for general public comment on their agenda. And we were informed that many, if not all, of the committee meetings of the Board of Supervisors do not have a general public comment agenda item.
I believe that is the case, yes.
Right.
The general public comment, is my understanding, is reserved for the full board meetings, and that it is limited to items that have not previously, to issues that have not previously been heard in committee.
Right, and that the second part of that is a carve-out, and that's specifically in the ordinance. But the first issue, I don't see authority in our ordinance for not having general public comment at a committee meeting.
I couldn't speak
No.
to it. I'm not familiar with the issue. Yeah.
I mean, I guess what we can do is spell it out. Then in A, every agenda for regular and special meetings shall provide an opportunity for members of the public to directly address a policy body, any items of interest to the public. And just after it says section 67.E of this article, just say, including committee meetings of the Board of Supervisors.
It does appear from looking at the provisions that you're identifying that they do require it for any meeting. of
Any
the Board of
meeting,
Supervisors.
any meeting of the policy body.
Yeah, it does appear that way.
And I believe there's one case, one of the Chafee cases, that doesn't address this issue, but basically reiterates that the ordinance requires general public comment at every meeting. In that case, that particular case dealt with a situation where general public comment was taken at the meeting was continued, and Mr. Chafee thought he was entitled to second public comment at the continued meeting, and the Court of Appeals said no. You're entitled to general public comment one time during the meeting. The fact that it was continued doesn't give you a new right to additional public comment, but they reiterated the fact that the ordinance provides this. So to me, it's already provided for. Again, maybe this is a situation where a member of the public needs to bring a petition for writ of mandate to force the committee meetings to take public comment. But if we want, we can spell it out. I mean, my concern with spelling it out is I don't want to imply that it wasn't there all along. You know what I mean? But maybe it would be appropriate to do so.
Chair Green, one way you could avoid that implication is simply by, in your notations explaining the reasons for the change, you could say this is a clarifying amendment intended to just ensure that there is public comment. It was always intended that there should be.
Right. So can anyone explain why we moved, this is just off topic, but in looking at this, why we moved the underlined language on page 88 in paragraph B from A? It says move for consistency, but I'm not really sure why we moved it. When writing that, I was like, well, why did we move it? For consistency, it seems to go better with A, not B. Unless I'm missing something.
Unless you wanted it to be in both places. And the first, and A you were talking about.
It would seem that B is dealing with special meetings, right? So.
Although A starts out every agenda for regular and special meetings.
Right. I don't know. This is maybe one of those situations where when Mr. Darby was going through and making the changes that something was not crossed out. Yeah, it would seem to me B is a little bit different. B doesn't deal with general public comment. B deals with comment on the topic for which the special meeting has been called, so it's slightly different. Does that make sense? So, for example, general public comment means at every meeting, at every regular and special meeting, you have to have general public comment.
Okay.
And then B is
that's
just
A.
saying, oh, and by the way, for special meetings, which are generally called to address usually one or a limited set of items, it's just reiterating that you have to have public comments there. And what I would propose to do is at the end of, on page 87, where it says, unless the action is otherwise authorized by section 67.E of this article, insert this requirement applies to all meetings of the Board of Supervisors, including all committee meetings Are there any other policy bodies that are spun off from the Board of Supervisors that I'm ignoring? There's committee meetings. So the Board of Supervisors has various committees. I just want to make sure by saying this including all committee meetings, I'm not excluding anything inadvertently. Does that make sense?
With the Board of Supervisors proper, I believe it would, saying committee meetings would include everything. The Board of Supervisors also sits as the Transportation Authority and also as the, what is it called? Not redevelopment, no. There's a, it's slipping my mind. It considers whether to adopt a municipal public power. I can't remember the name of the body.
Local Agency Formation Commission.
LAFCO, right, yes, yeah. But those are separate agencies, although it's the Board of Supervisors that sits, yeah.
Right, those are probably covered by the Brown Act, I would think. So if we say this requirement applies to all meetings of the Board of Supervisors, including all committee meetings thereof, does our grammarian agree?
How about this provision shall apply to all meetings of the Board of Supervisors and its committees?
Yes. Much better. This provision, provision's fine. This provision shall apply. See, I'm worried about putting that in to all members of the Board of Supervisors and its committees. It's troublesome because when you look at legislation, you see something like that. It seems to imply that you're limiting the prior, and we're not limiting the prior. Maybe I'm just being a worrywart. Does that raise a concern for you, Jerry, or do you think that?
Can you tell me again where you're inserting the language?
On line 24 on page 87, so unless action is otherwise authorized by 67(7)(e) of this article, this provision shall apply to all meetings of the Board of Supervisors and its committees. And then I would actually move up our deleted language, put it back where it belongs from B.
If your concern is that you would, by implication, be saying that it's not applicable to other policy bodies, you can simply spell out that this is not intended to limit it to the Board of Supervisors. I mean, there is somewhat of an implication by calling out the Board of Supervisors that you would be attempting to limit the provision.
Right.
So if you wanted to apply to all bodies, I mean, you can simply say it applies to all policy bodies.
All policy bodies and their committees.
Or you could have a separate subsection which specifically calls out the Board of Supervisors.
Maybe that could be the new B, B could be C.
What if we had as B the information that we had moved, the underlying information, basically just saying, which provides the Board of Supervisors the ability to not have public comment on specific items that have been considered by a committee, which we just moved simply. There's no substantive change intended. And at the end of that paragraph, say, however, nothing in this subsection is intended, nothing in this subsection basically, nothing in this subsection is intended to excuse the Board of Supervisor committee meetings from having general public comment.
Or you could say nothing is intended to, in this subsection, is intended to exclude Board of Supervisors committees from
This requirement?
Yeah, from this requirement.
Or exempt might be a better word than exclude.
Yeah.
Exempt Board of Supervisors committees from the requirement of having general public comment at okay, so However, nothing in this subsection is intended to exempt Board of Supervisor committees from the requirement to exempt Board of Supervisor committees from the general public comment mandate, not mandate.
Or maybe refer back to
General public
to
comment,
A.
right, specified and described in A. That's what I'm
Yes.
trying to get there.
Yeah.
The general public comment required
Under this section.
under subsection A. How does that read? So A is as is now. B starts with the deleted language that's now in B. Then at the end of that, we would say, however, nothing in this subsection is intended to exempt Board of Supervisors committees from the general public comment requirements under subsection A. And then the one sentence about special meetings would just become C. We'd have to renumber all the rest.
And then time and order of public speakers would become D.
Exactly. And D would become E, and E would become F, and F would become G. Do you think that meets what the supervisor's office was trying to do, Rick?
Yeah, it sounds good to me. I think.
Chris, did you follow that?
Yes.
Okay. Right, those were the only specific proposals we had, but then I believe Member Washburn also did a very good line edit.
Line edit, and then there's a couple of things of substance. Let's see. Looking at page 32, and that was the version that from last meeting. It's about departments reviewing previously undisclosed documents and then deciding that they can be disclosed. I was wondering about a requirement to have them notice, post a notice that this review has been done and that the documents are now available. Or would that be an undue burden?
Well, I think they're going to claim that this whole section is an undue burden, but this is a section
Well, then
that
we should go for it.
former member Comstock suggested, which I think is I believe other states have this provision. I'm trying to find out where it is in this particular revision. I believe it's new. Let's see.
It's on page 32 of this version.
It's on
as well.
31 and 32.
Right. So.
That's 32, you're correct. Review of closed session justifications on page 83 of the packet. It requires them to adopt a resolution stating that all information that can be disclosed has been disclosed. The resolutions also state when and under what terms the remaining materials may be closed. And then what you're suggesting is there also be a notice requirement.
Right, the resolution should be noticed. I mean, maybe that's done anyway, I would imagine it is, but I mean, to spell it out. I mean, to, notify the public.
So members of the public would be able to understand or receive notice that additional information has been provided that had previously been treated as closed session information.
Right.
I think that's good. I mean, we didn't want to definitely get into too much detail.
Maybe a
In there-
clause would fit.
Pardon me?
Just a simple clause.
Yeah, no, I mean, I think that's right. I mean, I think that's why we put in number 3, that the Sunshine Commission is authorized to adopt any rules and regulations necessary to implement this section. But, we could say, including requiring policy bodies public body. Why do we use the word public body there, not policy body? Because only policy bodies can have closed sections. Isn't that right, Jerry? Or can passive meeting bodies have closed sessions?
It's a question that I can't answer at this,
Right, yeah. Neither can I at this hour. Anyway, I'll look at that we might have used public body for a purpose. But we can say including requiring public bodies to post notices or otherwise inform the public that past closed session materials have been released or are now publicly available, are now open to the public. How about that?
Disclosable, or now disclosable.
Are now disclosable. Even better, fewer words. So basically, it would be after 3, the Sunshine Commission is authorized to adopt any rules and regulations necessary to implement this section, including requiring public bodies to post notices or otherwise inform the public that past closed session materials are now disclosable.
Good.
Perhaps one way to do that would be through the minutes of the body's meetings.
Right.
Right, because they have to adopt a resolution. I mean, we could actually if that would be sufficient for you, we could just say at the end of 2, instead of having at the end of 3, put a comma with how materials may be disclosed for publics and notify and not notify and list what materials past closed session materials past session materials are now disclosable. So we could move it up to
Yeah, I think we should. That should be a part of the procedure that is followed.
Okay.
Yeah.
So it should be
And
under
leave 3 for things we haven't thought of yet.
F1, 2, at the end of 2, say the resolution shall also state as precisely as possible when under what circumstances any remaining withheld materials may be disclosed to the public, and list it really should go up under the second sentence. The third sentence, if the public body determines that any part of the previously withheld materials can now be disclosed, it shall do so, and
List
list
and or maybe and identify each of the documents available.
and identify in the body's minutes past closed session materials that are now disclosable? How about that? So that, what it would read then is under F2, third sentence, if the public body determines that any part of the previously withheld materials can now be disclosed, it shall do so and identify in the body's minutes past closed session materials that are now disclosable.
Yeah, I think that's clear.
It's probably the best place for it.
Oh, the other, page 24, the, how big the font should be so that people could read it. And I was trying to figure out how to state it, but it was too late when I was working on this. Nothing came to mind, but 20/20 vision refers to distance vision, so it's not.
Page 24, line 4. Is this 24 of this document, right?
Yeah.
Okay.
Yeah.
Where do we have that?
Lines 14 and 15, yeah, line 14.
I don't know why.
So that even a person with presbyopia can read that. I don't know how to say it, but 20/20 is not relevant.
Right, the materials that are distributed at the hearing. This was, wasn't this Doug Comstock saying that he was offended that people would always produce illegible attachments to documents, and he thought that was just terrible. And so that's what it was addressed to.
Should be of a quality that they can be read.
It does seem a little.
That they are legible. Yeah, legible.
The materials that are distributed at the hearing shall be of such a quality that.
It should be clearly legible or easily read.
Anyone?
Such a quality that they can be easily read.
Or do we need the sentence? I mean, I'm not initially a fan of the sentence.
I would suggest clearly legible. I mean,
Clearly legible, yeah.
Clearly, is it emphatic and legible, it's
Means you can
obvious,
read
but-
them.
Yeah.
So materials that are distributed at the hearing shall be clearly legible?
Right.
There may be circumstances where there is no clearly legible
Copy.
but, that,
Yeah, that's true. Yeah, faxes of fax, or, Xeroxes of Xeroxes of Xeroxes.
Right, I mean, that's why I wasn't a big fan of the language, because it seems that, I think generally speaking, most people try to make copies that are legible, but what happens if, the only copy that the city has is one of those horrible blurred, printed off of old microfiche copies? I mean,
Well, what
what do you do?
you can always say to the extent possible.
To the fullest extent possible? No?
I think clearly
Clear
legible
legible.
does it.
Rick?
The word fullest is not necessary. The extent defines it.
All right, shall be clearly legible. If someone brings a complaint under this, I'll refer them to Member Washburn.
Okay,
So did you want us to just start and go through each of them, page 8? Because we didn't really go to that one.
yeah, I guess so. Some of them are really,
Conduct of business, too broad for this section. Line 13. All right.
seems to be dealing with because we have, I've found, it's been a while since I read this, but I have a note to myself that sections 67.4 and 67.6,
Have different titles.
well, yeah, but they also overlap in that there is some discussion about passive meeting bodies in 67.6. I just found I was getting lost here. For example, 67.6D is meetings of passive meeting bodies.
Right, that requires specific types of passive meeting bodies that are more important. You know, that this might be a situation where we need, this is one of the situations that we have to go through and make sure that we've made consistent changes. So this refers back to 67.3 D5 and D6, which deals with advisory board, commission, or committee or other body created by the mayor or a policy body or any advisory board, commission, committee created by federal, state, or local grant. So that those provisions only deal with those. Basically requires them to establish regular meeting times and requires them to provide, to deliver notice to people who have requested it in writing. But we didn't feel like those requirements were necessary on all other passive meetings. Does that make sense?
Yeah, I see that. It's just, I was looking at, okay, this section's going to talk about passive meeting bodies, and this section's,
I agree.
yeah.
This
so-
is, the prior ordinance was not clear on these sections, and the intent of these revisions were to clarify, and I'm not sure we've quite gotten there yet. Because it's very difficult. I mean, the city attorney's office has had a hard time identifying what, in fact, is a passive meeting body in some instances. And so, I mean, that was the goal here, was to actually make these three sections really 67.3, 67.4, 67.5, and 67.5 is not an issue, but 67.6 clearer. And if you don't think that it's clear yet,
It wasn't, yeah, I was really struggling, and so I think we have to get this nailed down, really clarify it, so that we all understand it clearly. Oh, it looks like we won't make the June ballot. This is
right, it's
so
still,
hard to think about.
I think part of the problem,
I didn't review it today, so
your mind is not fresh, I understand that. Yeah, I think what happened was we changed the definition of advisory, because there was all of these inconsistent. So if you see 5 and 6, they basically start looking like advisory bodies. And we wanted to make it clear that those were, in fact, at least 5 was policy bodies, and 6 might be advisory still because they're created by different grants. They're not created by the authority of the city. But we wanted to cover them in some ways to the extent we could. So, yeah, it's still messed up. And this is one of those sections that needs a real serious, or part of the amendments that really needs a serious look to make it consistent.
Yeah, it's foundational to the rest of the document.
It
so-
really is.
Yeah,
It really
it's
is.
got to be right.
And so if it's not clear, we need to go through that. Maybe we can have a hearing just on these definitions again and make sure that they're 100% correct.
67.3 through 6?
at least.
Yeah.
It's probably set, including 7, which deals with agendas, and 9. Yeah, I mean, I think that carries us through the definitional sections and the agenda and notice requirement sections, which differ depending on what type of body you are.
And that isn't easy to determine sometimes.
Not at all. I mean, it hasn't been easy. And I mean, I think one of the things we wanted to do with this process was make it clearer.
Right.
I'm not sure we've gotten there. We've made some attempts at it, and then I think we just kind of threw up our hands and said that's our best try for now and moved on. So I mean, I definitely think that it needs to be looked at more closely. Okay, so
Are
there anything easier? I mean, do you want to go through them line by line?
No, because one thing is just serial commas. I know there's debate over whether you need the last one. I'm of the mind that you do, so you avoid eats, shoots, and leaves. So, to ensure there's clarity, I like to put them in. I require my students to. We follow APA style, so.
Right,
This is a
okay.
legal document, but I don't know. That's just my druthers. I think it adds to readability.
Okay, so basically then the comments on page 13, 14, 15, 17, and 17 are editorial and typographical, and we can approve those without discussion.
Which are these now?
13, 14, 15, 17, and 17.
Gotcha, yeah.
Okay.
And then 24 is just inserting it's just a space.
Okay.
We've talked about 32. 34, residence members. I don't know which of those two nouns it was meant to remain.
Okay. 32, Ray 2, this is the notice. We've done that.
Right. So
Okay, and
it's
so
34, line 6.
edited.
There's residence members, the two words run
That's the
together.
context. It seems to me I sent something on that a little while ago.
You may have. Unfortunately, we don't have.
Let me see.
Track of that.
34, line 6.
Is to enable San Francisco residents or members of the public. It should be one or the other.
Yeah.
And it should be members of the public, not
Right.
San Francisco residents. And
Right.
so it should be members of the public.
Cross out San Francisco residents.
It doesn't even, yeah, it doesn't have to be San Francisco.
No, it does not. There's no limitation.
34 is a comma misplaced, and the date is 2010. It's on the same page at the bottom. That'll have to be updated. As long as it isn't 2013 like the healthcare reform we may get.
2010 may still work. If it passes in November, it's probably, it would be better to put within a certain number of days of the enactment.
We've
of
already,
ordinance.
34 line 21 has already been addressed. And I'm kind of surprised that the language isn't already changed in here.
The problem is that Chris and I haven't figured out a good way of tracking this yet. And so what Chris has been doing is basically keeping in all of our minutes
Okay.
notes of what's been changed or what we've approved to have been changed, but we haven't figured out what makes sense in terms of a working document because we got into such trouble last time with a Word version of track changes that was 9 million kilobytes big and,
Yeah.
and
Right.
corrupted.
Right,
And so
yeah.
some of this may have already been changed.
Okay.
But we can make, instead of saying we're going to do something about that, we can make it, if you believe it's already been changed, then,
Yeah, I believe that's already been addressed.
okay.
I think we decided there should be like a 6-month window? Or
after enactment of the ordinance,
or maybe it was a 9-month, I don't remember.
right? I think that's right.
I think we just said it was,
Oh, we already addressed it before, so I can't remember what it was, but we can look back at the minutes, because that's where you've been keeping the changes. All right, so,
And 35 is, I've noticed where public body is capitalized some, oh, well, there's also policy body too.
Right.
Capitalized in some places and not in others. So I'm not sure which it should be.
I think it's lowercase,
So that should be,
so just lowercase there.
yeah, it varies. That's a problem throughout the document. 38 and 39 are just edits. No, page 42 is something of more substance. 42, line 3. I think which, it reads which,
yes, I agree, shall should be the word there.
okay.
That's fine, the may versus shall, ever. Consistent issue.
Page 52, I wasn't clear about what was meant by whether system was a computer system or could be any sort of system. I understand a new software, but I don't know what system refers to. So it's there, it's later on, page 72 as well.
Also, I think the word new is superfluous there. If you're creating something, it's going to be new.
Right.
Computer program or computer system, would that be clearer? Or is it fine to read, create a computer program or system?
Or could it be method? I mean, you could. I mean, you might have a program with, that has a bunch of menus and defaults and stuff, and it wouldn't require programming, but it might be changing a default that works for, everything that you're using the program for. Yeah, so I don't know what that means.
Basically, it's the intents, I think, of the state law. We're trying to make this consistent with the state law. The state law provides that you don't have to, I'm assuming that language came from the state, but maybe not. Basically, you don't have to reprogram your computer, create a new system to run to pull the data out. You don't have to do any of those things to respond to the request. To create a computer program or system. It's really electronic system. We don't mean like method. I mean, we're not meaning you can avoid, setting up an internal mechanism of people to review documents to respond. You have to do that, but it's really about manipulating the electronic, the information stored in an electronic manner in a way that is beyond simply just.
Also on line.
Maybe it's fine to just say to create nothing in this section shall require them to create a computer program. Or electronic system. We want to make clear that the problem with this, that's fine. So delete new.
Maybe even delete, create a new computer program, because a new electronic system.
Well, but you're not, basically, there's a fine, it's a difficult issue under state law. State law provides you're not required to, it was developed back in the day when computer programs were much less flexible than they are now, which is part of the problem, but that you're not required to reprogram hire a computer programmer to sit down and basically rework your system for 20 hours to be able to produce information that you want that's maintained in this database, right? But that's what we're saying you don't have to do.
Right.
But what you do have to do is say, if it just means, running a certain query, right, or, pulling information from a database that may take you an hour or two to figure out the right query, but the information is in that database, but you have to design your query to make sure you're not pulling exempt information, they are required to do that, right? And so that's the tension. So we're basically pretty much copying state law, which I can't remember what it says right now because I don't have it in front of me, I don't think. Let me see if the state law is in here.
Well, while you're looking that up, on line 11, before the word would, insert the word that.
Nothing in this section is required to create a computer program or request for information.
Something else there.
But I don't think that solves it.
That does.
Nothing in this section shall require a department to create a computer program or electronic system to respond to a request for information or that would jeopardize?
Or two. Maybe you need two in there.
No.
Or that would jeopardize?
Well, all right.
No, it's basically, or,
No, that's, all right, in that case, no, the word that should go there. What we could say is, nothing in this section shall require a department to create a computer program or electronic system that would respond to a request for information, or that would jeopardize or compromise, etc. So instead of say to respond, say that would respond. Then we have the consistency of language.
Yeah, I agree.
nothing in this section shall require a department to create a computer program or electronic system
That would respond to a request.
that would respond to a request?
Yep.
That doesn't, hold on, I'm having a problem with that. Electronic system that would respond to a request. Yeah? That would respond.
Madam Chair,
Okay, yes.
may I suggest electronic software instead of electronic system?
No, because a system is hardware. A computer program is software.
I mean, if you look at the prior language, it was reprogram a computer was the, so if you're reprogramming a computer, are you affecting its software or its hardware?
Software.
Software. We haven't had these exciting conversations in months. Can you tell why we're not excited to go back and do them again? So it's addressing software already.
We could say create electronic hardware or software.
Word electronic, though.
You're going to say hardware? Yes. Hardware can also refer to hammers and nails.
That would be much easier. Dealing with those. I don't think the Good Government Guide has the provision on electronic records in it.
May I make a suggestion?
Yes.
I don't think there's good agreement about what the terms hardware and software mean at this point.
Exactly.
And one way to describe it might be computer applications and operating systems.
Nobody would ever think of adopting an operating system to answer a query, because that runs your whole computer. Application would.
Well, if we're considering it from the perspective of the agency, I don't think anyone would ever think of creating a computer program to answer a query either.
Right, right. So what is it we don't want agencies to have to do, to spend
Expend a considerable amount of money.
time and
to-
money?
yes.
Yeah.
Right, it's basically if you have to run a query, you have to create a
Right.
query to be able to pull information out. That's fine, because that's a relatively easy task, but you're not required to hire a programmer to sit down for 40 hours.
Right.
And
It's
take it
akin
out.
to someone going and searching their files, essentially. I mean, they're certainly required to do that, but they're not required to create a new filing system or create a document in order to produce it.
I mean, the concept is hard when you apply it to electronic records, right? Of creating a document, what does that mean? And this is exactly what it's trying to help determine.
I'm trying to think of some complaints we've had.
We've had complaints about databases, and we've required the agency to basically come up with queries if their claim was that some of the database has exempt information, which ordinarily it does, to come up with queries that would pull releasable information out, provide it to the requester in electronic form. We really haven't come across a situation where there was this other issue, where you had to reprogram.
I can think of an example where there might be a field that that has some information that could be retrievable, but the database doesn't have the field as one of the things you can query on. So you'd have to create that and then have some way for the database program to figure out, where that is in the document.
I mean, with the state, I did find the state law. The state law has something a little bit different that I think our ordinance wanted to go beyond. Basically, the way the state law is the requester shall bear the cost of producing a copy of the record, including the cost to construct a record, and the cost of programming and computer services necessary to produce a copy of the record when either of the following applies. 1, never mind. 2, the request would require data compilation, extraction, or programming to produce the record. So that's what the state law provides.
Data extraction.
And so what we're saying is, nothing in this section shall require a department to create a new computer program or application to respond to a request for information. I mean, I think that makes sense. Computer program or application to respond to the request for information, comma, or take any action that would jeopardize or compromise the security or integrity of the original record or of any proprietary software in which it is maintained. Does that make sense? Rick, does that make sense? Jerry, does that make sense? So it would read, nothing in this section shall require a department to create a computer program or application to respond to a request for information, comma, or take any action that would jeopardize or compromise the security or integrity of the original record or of any proprietary software in which it is maintained. Better?
Yeah.
This is painful, but it's exactly the type of labor-intensive review that unfortunately needs to be done, because there are so many of these instances in the old ordinance and in the revisions. So I appreciate everyone's patience.
On page 54, I'm just asking that a which be changed to a that, because the clause is restrictive. I don't remember what it was, but,
Yeah, that makes sense.
and 54 is just a comma.
Yep.
61, okay, this is, there's language about, okay, we're dealing with misconduct that is substantial. In the case of employee records. So I imagine, who makes the determination about whether the misconduct is substantial?
It's a phrase of law. Well, actually, it's the holding of a court of appeals decision. So, like anything else, the department would make a determination as to whether it's substantial.
So that it's the department making that? Okay.
It's basically substantial is distinct from baseless or trivial, and there have been some cases that have helped interpret that. That standard came from a Court of Appeals case, and then there's been at least one follow-up case which interprets it. I can, it's not baseless or trivial.
Right. So anything that's baseless or trivial would...
It's insubstantial. It doesn't have to be true. Substantial
Right.
does not equal true.
Right, it says
or
allegations,
supported.
it says allegations of
Yeah.
misconduct. Okay. All right.
Can we stay with that for just a moment? When I reviewed this, I had a question that I just wanted to raise with you, and
Yeah.
maybe it makes sense, and I can't figure it out myself. It says all records regarding confirmed employee misconduct, and then further down in line 15, it says, and there's reasonable cause to believe that the complaint is well-founded. It appeared to me if it's confirmed misconduct, that there would have been a determination that the
Right.
misconduct had happened, and so there didn't need to be a reasonable cause to believe provision there. They seem to be inconsistent.
I think you're right. I think you're exactly right. I think that's probably a mistake in drafting. I think it was, this is what happened. See, I think this is one of the situations where it might have been, if you look at this, it says regarding confirmed employee, and the confirmed has been struck from the, I think our intent was to strike it, because what happened was the Sunshine Ordinance had a more restrictive provision in it than under state law after these cases came down. So confirmed should not be in there. Confirmed should be removed. It says all records regarding employee misconduct or allegations of misconduct that are, well, okay, never mind. This is why you have to read the whole sentence. So it's all records regarding confirmed employee misconduct, comma, or allegations of misconduct that are substantial in nature, as distinct from baseless and trivial.
Oh, I see.
And there is reasonable cause to believe that the complaint is well-founded, comma, then including records of any discipline or warnings imposed for such misconduct. So, I mean, really, it should be, to make more sense, to Jerry's point, this is confusing. It should be what it's trying to encompass are instances where employee misconduct has been found. It also encompasses situations where employee misconduct that of a substantial nature has been alleged, even if misconduct is not, in fact, eventually found. So I think it might make more sense to say all records regarding confirmed employee misconduct, including records of any discipline or warnings imposed for such misconduct, and records regarding allegations of misconduct that are of a substantial nature. Would that make it read better in terms of clarity? Because we don't want the ambiguity.
I think that would, yes.
Does that make sense for folks? Because basically what we're saying is once there's been misconduct confirmed, all records, including records of any discipline or warnings imposed for such misconduct, plus, so it would be and all records regarding about allegations of misconduct that are substantial. Let me try this. The way it would read is all records regarding confirmed employee misconduct, including records of any discipline or warnings imposed for such misconduct, and all records regarding allegations of misconduct that are of substantial nature as distinct from baseless or trivial, and there is reasonable cause to believe, and where there is reasonable cause to believe that the complaint is well-founded.
So we needed the in there.
That the complaint is well-founded, yes.
I think well-founded might need a hyphen. It's an adjective.
With a hyphen for well-founded, if appropriate. You've got the AP style.
No, it's APA. This
APA,
is just,
APA,
this
right.
is, yeah. Um, 71 and the 2 and 71 are just typo. Well, maybe the 71 line 6. I'm not sure what was meant there at all. There's a sentence fragment.
We on page 71? I'm sorry.
71 line
six.
6,
Thank
yeah.
you.
5 and 6,
We moved too
actually.
quickly then.
Lines 4 through 6. There's a sentence fragment. We could just take it out.
We just need to take out only. Shall be provided upon request of the actual cost of them of materials. Oh, I see, the $10 or less per meeting. For $10 or less per meeting. Yeah, we can just take out the rest of it. The $10 or less per meeting should go as well, right? So it should be copies of video, audio, or digital recorded meetings shall be provided to the public upon request for the actual cost of materials, i.e. tape, disc, CD, DVD. Hopefully this will all become obsolete when they're all posted online.
Right.
Does that make sense, Rick?
I would leave only in there.
Oh, yeah, that.
Okay.
And a comma after, i.e.
And a comma
tape
after
should
IE,
be.
and tape should be lowercase.
Yeah. And then 71 line 21 is just a typo. 72 is this page 72 line 25 is the same issue with system.
No, another? A new computer program or system.
Yes.
See, what? No, the question I have is why do we have it on in both areas? This is one of the things we need to go back and change, was we tried to consolidate.
So maybe this is the section for it and not the previous one.
Right. So let's see what we said in 52. We said,
New, or create a
said-
computer program or application.
new program or application to respond to requests for information. Oh, that's it. Or to provide access. That makes much more sense. Or to provide access that would jeopardize. So we may not need to, we may be able to delete that whole section, really, I, in 51 and 52, because it is here.
Right.
Yep, all of that information is here. That should have been deleted from this. Part of
yeah.
our efforts are to delete extraneous. So, Chris, we need to strike that whole
On page
section
52, yeah.
of I, because it is now there. And it should, my annotation should say provision amended to be consistent with the existing law and clarify moved to new $67.30C. Okay. Chris and I are going to have a meeting and figure out how to do this. Hooray.
73 is deleting A2, line 7. Wait, let me see.
73 line 7.
A2 to, wait. Into and, whoops. No, that two's, no.
The two's okay, right?
No, it isn't okay.
It is
Shouldn't
okay?
be there, no.
Which one?
On line 7.
If requested and if necessary, technology and equipment are available to transfer documents.
Shall, if requested, shall transfer, not shall to transfer. Every department and policy body shall
If
do what?
requested.
Shall transfer.
And if necessary. Oh, I see. Comma, transfer. You're right. You were very much right.
Okay, page 75, line 14, the link on each of these home pages, records and sunshine. I was just wondering whether everybody would understand what that means. Maybe something like public access to records. Because somebody may not know what sunshine means.
And especially because we're changing the name of the body from Sunshine Ordinance Task Force to the Open Government Commission. Am I right?
I thought it was the Sunshine Ordinance
Let's
Commission.
see. Maybe it's the Sunshine Ordinance Commission. The Sunshine Commission. So we're still going to have sunshine in the name. But the question is it still ambiguous?
Yeah, somebody who's not familiar with the Sunshine Ordinance, or what the concept of sunshine, wants some records.
It's an excellent point.
Access to public records.
You could say public records access or records access.
Yeah, public records access.
Well, what are some agencies doing now? I know a lot of agencies have that link on their website.
Records and Sunshine.
No, it's not Records and Sunshine. It's
Public records access.
it's
It ought to be in plain English, I think, rather than jargon.
link titled Access to Public Records.
Mm-hmm.
Is that what we're saying is clearest?
I think so. It's plain English.
I mean, maybe what we should do, and this is something that, I think we've been struggling with the whole time, is just say it should contain a link to a page or the name, phone number, and email of its address of its custodian of records. We should allow the departments to name it whatever they want, as opposed to saying you have to call it this. Chris?
Every web page has a contact us button there.
Right, but that's not what it- Right.
On the new website.
Right, but that's not what it does. It's supposed to link you to a place where there's basically sunshine-related information and sunshine-related documents.
There should be some kind of stipulation, though, because, as to what the link is titled, because some agency might decide to create the link, but it would, do it with some kind of obscure title that would not readily tip the public as to what the page is, as to what the link, where the link takes you.
The nefarious departments. All right, so access to public records? Is that the most basic thing then? Okay. All right. Page 80.
Is just changing the tense.
Okay.
91 is deleting an and. Um, 93 is inserting a comma. 94 is inserting of after violation so that the sentence makes sense. And then the one on page 97 and then the second one on 99 are two places that I thought the wording was unclear.
How dare you think our wording was unclear? 3 and 4. I think what line 3 was supposed to say is the commission shall include in its bylaws
Oh, okay. Well, that makes sense.
selection criteria and oversight of appointed council and expenditures. So that's just purely a, does that comport with your recollection, Rick?
Unless it refers to something in the previous sentence. I'm trying to read this now.
The amount of expenditure for outside counsel to prosecute these cases shall not exceed $50,000 per fiscal year, or such great amount authorized by the Board of Supervisors litigation fund. The
No,
commission
I
shall
think
include in its
I
bylaws.
think it comma should be replaced by in.
I agree.
Yeah.
Page 99, line 21.
That's a serial comma. Or no, that's after a prepositional clause.
Okay.
On page 97, the same sentence, it seems a little awkward and maybe unclear. The commission shall include in its bylaws criteria for selection and oversight of appointed council and expenditures. Currently it says selection criteria and oversight of appointed council. I'm not sure what it means to include in your bylaws oversight of appointed council.
So you would suggest
Criteria for selection and oversight.
What about the commission shall include in its bylaws criteria for selection of appointed council and oversight of expenditures?
Well, I think selection oversight of both. I think you want both. You want to oversight. You don't just want to select the council. You want to also oversee them.
But would you have selection criteria for expenditures? Or these are the expenditures for the appointed council?
Yeah.
Oh, okay. I was looking at expenditures as a bigger
It's really just the
category.
expenditures of the appointed council.
Right.
Do I think that makes sense, Jerry? So include in its bylaws criteria for selection and oversight of appointed council and expenditures. That's a good point.
And
Awkward,
then-
awkward. 23.
Yeah, I was having problems with that. Any meeting or portion of a meeting should be open to the public as well as the records of such meeting. The records are
Right, there
available.
shall be a presumption that the information shall is disclosable, that any meeting or portion of a meeting should be open to the public, comma,
That records of such meeting are available.
that records of such meeting are disclosable.
Yeah. And,
I think that you can have a period there.
yeah, the burden shall, yeah.
And then a new sentence. The burden shall be upon the respondent to prove with specificity that they have fully complied with the request and or that an exemption to disclosure applies. Because that's not a presumption, that's stating the burden.
The only other thing I had was.
That's good.
One more thing on page 69. Prohibited basis for withholding. Reference is made to California Public Records Act, Section 6255, and I was wondering if a note could be made about the major provisions of this, or is that, unreasonable?
It's basically reiterating what's in the ordinance currently, it's just moving it to a different section to make it clearer. Or just to reorganize it to make it flow better, but it's what's in there now. 6255 basically provides that there should be a balancing test, and that for any particular record where the court determines the public's interest in withholding outweighs the public's interest in seeing the document and releasing the document may be withheld. And one of the big differences between state law and this ordinance is that balancing test does not apply, could not be used as a reason to withhold records. I'm
just wondering if it,
It's not plain English, that's for sure, but
I'm just thinking in A, when you mention this
yeah.
California law. My first question was, well, what are the major provisions of this?
It's not that difficult to incorporate it in there. If you think it's necessary.
I should stop reading this as a college professor trying to help my students write more clearly. But
Actually, if we had you reviewing all ordinances in the city, it would probably do everyone a huge favor. Or a headache. Or a favor. I mean, this process has opened my eyes to what a bear it is to do legislative drafting. It's very difficult, especially with a huge piece of legislation like this.
yeah.
It's huge. I would leave it in there because basically C reiterates what A is. It's a little bit duplicative in some ways, except that it's, I guess, trying to be broader than necessary because there are some cases that have dealt with 6255 in a very broad fashion. So I would probably leave it. Maybe it's because I'm tired.
Yeah, I'm tired too. I almost didn't bring it up, but
Public comment on any of these suggested amendments? Seeing none, we will make the suggested amendments that we've approved. Jerry and Chris, can we perhaps have a meeting maybe next week, depending on our schedules? The three of us to figure out what makes sense going forward in terms of tracking changes that have been approved by this committee, as opposed to the kind of inviolate document that represents the changes already approved by the full task force. Because what we're going to need to do is go back to them with additional changes and say, we've revised some new language or added new language, wholly new language. We've edited or done typographical changes to the stuff you've already approved, and here's what we've done. So trying to make it something that makes sense both from the ability of the full task force to see what additional changes we're suggesting, but then being able to incorporate whatever the final document is in a document that's easy to compare to the existing ordinance so that the final is readily available, because that's the problem we got into before. So maybe we can talk offline and set up a date for the three of us to meet to figure out what makes the most sense.
I will be, Madam Chair, I will be in the office only on Wednesday.
Of next week,
of
only
next week,
Wednesday?
yes.
Okay, well, I'll look at my schedule. See if hopefully we'll have time. Okay, and if not, we can do it the week after, but we really should just make a final decision so that then when the document comes back before this committee, we won't have the situation where Rick says, we already changed that, so that it just becomes much more efficient for us as well as for you, Chris. Okay, all right, we'll do that. Thank you. Next item on the agenda then?
The next item is the administrator's report. I will be over the coming days and weeks increasing the amount of audio recordings we have online.
Great.
That concludes my report.
Madam Chair,
Yes.
I note that on page 3 of the report, there are a number of, in the third column where the dispositions are listed, there are several references here to the task force meeting of November 24th, and we should be reminded that that meeting is to take place on December 1st. You might want to, Mr. Rustam, you might want to revise the report if there is to be one at this week's EOT meeting.
Through the chair, I was waiting for the outcome of today's meeting to see what we need to, and if we needed to adjust items. So what will happen is first thing Thursday morning, the reminders will be going out.
Great. Thank you. Any other comments? Was there public comment on the administrator's report? Seeing none. Any announcements, questions, or future agenda items? Seeing none, we're adjourned. We take public, our practice is to take public comment on items not listed on the agenda as the first item after 5 o'clock. We did take that public comment, but I would open it up to public comment now. Please. Microphone, please.
Chris, is her microphone on?
Thank you. Please
Is it on
continue.
now?
Yes.
Okay. So I've been communicating with Chris, and I came personally into the office and gave him some documents pertaining to some information that was not being disclosed from the city attorney's office. But it had been public in 2004. But they gave me like 3 sheets of paper, and according to the press in 2004, there were actually 16 documents. So I gave a sample of 3 to Chris, and we've been communicating, and he sent me an email yesterday, I believe, saying that, and an attachment was something from Doyle Johnson, which had nothing to do with my complaint. And the reason I'm here is I have been getting the runaround from virtually every single department for the last 15, 17 years. Every department that doesn't want to deal with situations, but starting with the Department of Parking and Traffic Commission, sent me to another department because that's the way city does things. It's a lot of paperwork for them. So they say, oh, we'll call the health department. We'll call the building department. We'll call the fire department. We'll call the police department. Police says, call the building department. Call the DPT. Call the anybody but us, okay? So the reason I'm a little paranoid, and I am, is because I've been trying to get these documents from the city attorney's office because the problem hasn't gone away. It's just that a civil servant was responsible for a lot of the problems in the Department of Parking and Traffic. And finally, someone in the city attorney's office did listen to me, and I found out later, because they didn't communicate with me, that through media, that something had been done, but I didn't know what. So I started calling the city attorney's office, and they said they refused to give me any information whatsoever, even though he had it in front of him, which was interesting. So Doug Comstock, formerly on the Sunshine Ordinance Task Force, suggested that I didn't know about Sunshine. Nobody really does. It's one of the education things in San Francisco that's not very well known, by the way, that there is a process, though I'm not sure it's going to go anywhere, just like the police commission complaints doesn't go anywhere. It feels like it's a place just to vent. And the reason I'm here is because I'm afraid that I'm going to get lost in the shuffle unless I make a stand. I was just at the Board of Supervisors in their long list of people singing and reading from the Bible and everything else, speaking about this very thing, mainly because the clerk of the supervisors had been here at the last meeting, and he had talked about redacting, which was what I was worried about in the documents that would be given to me. Turns out they didn't redact them, they just didn't disclose all the documents, which I know there were more, because
Okay.
it was even in the press.
Yeah, I think the time is up for public comment.
So the reason I'm here is I want to make sure that the documents that I gave are going to be attached and seen, and I'm afraid that if I don't say things,
Okay.
it's going to get lost.
Thank you. Your time's up. Thank you for the comment. Thank you for public comment. Just as an inquiry, Chris, did you receive some documents?
Madam Chair, yes, I received a complaint from the speaker. Excuse me. What had happened was, as soon as I sent out your complaint has received notice, DCA3 emailed me to say that there was I had made an error and included a document I should not have included. 5 minutes later, I sent out an apology to all people concerned in it and saying that the correct document will be forwarded.
Okay, and you did receive underlying documents related to the speaker's complaint, and those will be included in the packet?
2 supporting documents, yes.
All right, thank you.
2 one-page supporting documents.
Okay. All right, thank you. All right, the meeting is adjourned now. Public comment is closed, the meeting is adjourned. Thank you. Sorry, I missed that. Get down to the excellent journalists.